Hello and welcome. Today is February 26th, the third day of the confirmation of charges hearing of former President Rodrigo Duterte at the International Criminal Court. You are watching Rappler's special coverage. I am Jairo Bolieto. Today, we are joined by human rights lawyer and National Union of People's Lawyers President Efrain Cortez and San Sebastian College Recoletos Graduate School of Law, Dean Rodel Taton. Later, we will be hearing from Rappler reporter Lian Buan and Rappler correspondent Michelle Abad, live from The Hague. You can join this conversation by posting your questions or insights at the Justice and Crime channel of the Rappler app. You can scan the QR codes below. Later, we will go through your insights and read some of them. The hearing has already started at the ICC, but the broadcast is delayed for 30 minutes. Lian Buan is already inside the chamber, but she filed this report earlier.
Good morning. This is day 3 of the confirmation of charges hearings against former Philippine President Rodrigo Duterte. I am Lian Buan. I'm reporting live from the International Criminal Court, where a few minutes from now, lead defense counsel Nicholas Kaufman will present his submission on merits. Inaabangan to ng all sides because up until this point, Kaufman and his associate counsels have been arguing this case based on what they claim was a lack of jurisdiction. Now, natalo na sila dito sa kanilang jurisdictional issue, but this current issue is on appeal and they are still waiting on that jurisdiction issue. Many of them in Team Duterte, including Kaufman, including the 6 assisting Filipino counsels, think that jurisdiction is their biggest issue, but seeing that that's still on appeal and Kaufman will have all of today to submit his submission on merits, inaabangan kung ano yung sasabihin niya na hindi jurisdictional related. Based on his opening statement on Monday, we can expect him to say that the rhetoric of the president is only hyperbole, it's only bluster. We can expect him to say that his words, that his rhetoric should not be prosecuted for crimes against humanity. He did say on Monday that the intent, a sole intent of the president was to instill fear in people's hearts to be able to make them follow the law. And what he said, it's not a criminal intent. Everybody's anticipating how Kaufman would respond to the submission on merits of the prosecution. To remind yung ginawa ng prosecution, sinimulan nila sa mga speeches ni President Duterte na sabi niyang ipapapatay niya ang ilang mga tao, papunta dun sa napatay talaga yung mga tao, papunta dun sa Excel sheet ng PRRD list na nakalagay talaga dun na neutralize yung taong namatay na sinabi ni President Duterte na kanyang ipapapatay. So yun yung linkage na present ng prosecution at they say that those are sufficient or at least at this stage substantial reasons to believe that former President Rodrigo Duterte was an indirect co-perpetrator or mastermind of the policy of killings. Kanina na-interview ko si Father Bert Alejo, one of the priests who work in helping victims of the drug war and helping secure witnesses and witnesses information in the last 10 years. And he was saying he also is anticipating what Kaufman would say. And sinabi na ng mga lawyer ng mga victims kahapon that they should be prepared to hear unpleasant things today. Victims have been warned that today's session might be painful for them, might be hurtful for them. But their lawyer, Gilbert Andres, said they are mentally prepared because they have been waiting 10 years for this process. Sabi ni Father Bert Alejo, kanina sa mga biktima ay wag matatakot dahil they're on the side of the truth. So day 3, today will all just be Nicholas Kaufman presenting his submissions on merits. And tomorrow, day 4, he will have another chance to extend that on the closing statements. And the latter part of day 4 would be devoted to the yearly review of the detention of the former president. Bukas wala ulit yung dating Pangulo dahil pinayagan ulit yung kanyang waiver na hindi umattend. So in a few minutes from now, we'll be starting the session with Nicholas Kaufman. Stay tuned to Rappler for our updates and breaking news from the International Criminal Court and outside, where supporters of the president and human rights advocates watch on to see what the defense has to say.
That's Lian Buan, our senior investigative reporter, reporting from The Hague. We now have with us Rappler correspondent Michelle Abad, who's covering outside the court. Michelle, what's the atmosphere there? Any updates?
Yes, good morning, Jairo. I'm outside the ICC for day 3 of the confirmation of charges hearing of former President Duterte. I'm sure Lian mentioned it in her report, but today is attorney Nicholas Kaufman's day, with the defense taking the floor for the entire day. And it's the full day for the defense to debunk what was put out on the table for the allegations against the former president, and it's a listening day for the victims. Just to remind also our viewers, the former president has waived his right rather to be present at the hearing, and he will not be there to defend himself. I'll just give you a little bit of a recap from the day yesterday, especially since there was a break. So yesterday in the break, there was a bit of time for some of the parties to really just take a break and reprocess some of the things that were already mentioned in the hearing so far. Yesterday I was at Duterte Street, the so-called Duterte Street, which is a fenced area from the ICC grounds where the ICC detention center is, where the former president is detained. There was a media interview given there by some of the pro-Duterte lawyers, Salvador Medialdea, Panelo, and Martin Delgra, who are former appointees of the president, and they gave a press interview at Duterte Street, and they were really just asked to give some views on how they thought of the hearing so far, and they basically echoed the defense of what Attorney Kaufman has already given in the opening statements. So basically, they had this view that this case is still political, that it had weak evidence. For Medialdea, for example, there were he said that he called them theatrics, baliwala daw ang ebidensya. He compared what was described as crimes against humanity during times of war. There were hundreds of thousands killed, and sabi nga niya, in these previous discussions of what crimes against humanity are, and former Executive Secretary Medialdea said that the former president did what he had to do to clean the nation. And he also said that the words that were used from the former president's speeches were taken out of context, and that if you would listen to the full speeches that the former president gave, that he actually had a bigger meaning, or that it wasn't necessarily to kill out of the bounds of the legal system. And so basically he said that nothing was substantiated. The same things were mentioned by former LTFRB chairperson Martin Delgar, who was also here, and said that the evidences given by the prosecutions and the representatives of the victims was nothing more than a rhetoric, a narrative. They denied, and Mr. Delgar also denied, that this was a war on the poor, and that the former president was for the poor. And he also focused on the political character of this case that he believes in. For example, he said he substantiated this claim that this case is political because of the fact that the Philippines has a policy to bring home incarcerated Filipinos, whether they are in trial or even convicted, as much as possible, to bring them back home to the Philippines. And he even likened the case to the one of overseas Filipino worker Mary Jane Veloso, who by the current president Marcos was brought home to the Philippines, even though she was serving her sentence in an Indonesian prison. So he's saying that this is proof that this is political. Kasi bakit hindi daw magawa ng Administrasyong Marcos ang itong effort para maibalik ang presidente? So this is the reiteration of their claim that this case is political. And they also wanted to say that there are questions also raised on whether they were cooperating officially with the defense today. And they said that not technically cooperating as of now, but they were just witnessing, but maybe down the line. Former Chief Legal Presidential Counsel Panelo said that his son Paulo had applied for him, as far as he knows, to be accredited at the ICC. So let's see what will happen there. But as of today, they are confident that Attorney Nicholas Kaufman will do well in defending the case.
Yeah. Michelle, just a follow-up question. In the last 2 days, you were able to talk to the supporters of the former president, and in the last two hearings, it has been established that they were not really, into witnessing the hearings itself. They told you that they would like to, watch the hearings later on. Hindi sila nanood real time. How about today? This is Nicholas Kaufman's day. Basically the defense lawyer of the former president would try to rebut the submissions of the prosecution and the victims. Nakausap mo na ba sila? Anong sabi nila? Would they watch today or what?
Actually, yun din yung natanong ko kahapon sa Duterte Street. Siyempre, after ng press interview with the Duterte lawyers, tinanong ko din yung ibang na nakilahok dun sa Duterte Street kung manonood na ba sila ng live stream today, especially since Attorney Kaufman will have the floor. At sabi nga nila na talagang manonood daw sila live, if not in the public gallery, then also outside with the live stream.
Thank you so much, Michelle Abad. That's our Rappler correspondent. And now Michelle will join Lian inside the chamber to cover the day 3 of the confirmation of charges hearing of former President Rodrigo Duterte's ICC cases. Thank you, Michelle.
Thank you, Jairo.
Now let's go to our experts here at the Rappler newsroom. We have Dean Rodel and Attorney Efrain Cortez of NUPL and Dean Rodel of San Sebastian College of Law, Graduate School of Law. Today is Nicholas Kaufman's day. Day 3 is dedicated entirely for the defense to, rebut, provide their evidence or submissions on the merits so far presented by both the prosecution and the victims. Meron tayong peek on how Kaufman would present the submissions during his opening statement. Kayo po, anong nilook forward nyo sa statement niya? Paano nyo po in-expect na i-rebut ni Kaufman yung lalim ng evidence so far na ipinakita ng prosecution at ng victims? Let's start siguro with Attorney
Yes,
Cortez.
going by his opening statement, more or less we can already predict what are the evidence that they will going to, or how they will rebut the case presented by the prosecution. The problem with them is how can you prove politically that the case is politically motivated? How they can rebut or present proof that these are mere rhetorics and hyperbole. So I'm interested to know what are the pieces of evidence they will be citing when they try to prove a defense based on those on that is politically motivated. And actually, in essence, the defense is mere denial of the charges. So we have not seen any substantial defense that they presented when they summarized their position during the opening during Kaufman's opening statement.
Yeah, and that's really interesting coming from Nicholas Kaufman, who accused the defense counsel of, political demagoguery, but he resorted on political attacks.
Yes.
Yeah. How about you, Dean?
The same. We are expecting here that they will counter the evidence. For me, there is a substantial ground that's presented by the prosecution, but we'll look at how they will deny these aspects. And at the same time, as we said, they will counter motive, which is political, and also on the aspect of the statements of former President Duterte, which are, I think, quite hard to counter, and they cannot deny that. No? So we'll be looking at how they will prove lack of intent or denial or other defenses there. But as an observer here, we are really looking at them destroying some statements presented, the videos presented. In fact, I was also trying to look into social media today, and there were affidavits coming out saying that some of the videos were not authorized and all that. So it's interesting to see how they will present this and how it unfolds today.
Yeah. For our viewers who just tuned in today, this is the third day of the confirmation of charges hearing. The ICC proceedings ay sui generis siya. Hindi siya katulad ng ibang mga proceedings katulad sa Pilipinas. This is a unique setup because in the Philippines, after na makita ng prosecution na dapat kang sampahan ng kaso sa korte, iakyat ka na agad sa korte. In the ICC, meron tayong pre-trial na tinatawag at nandito tayo sa stage na to. So after makakita ng prosecution ng sapat ng ebidensya para hingin sa korte na maglabas ng warrant, nandito na tayo ngayon sa pre-trial kung saan binivet, chine-check ng pre-trial chamber kung dapat bang umakyat tayo sa trial. Bali po, ang pinag-uusapan po natin dito ay substantial grounds. Meron po bang sapat na ebidensya ang prosecution at ang victims para i-please ang korte, ang pre-trial chamber, para umakyat po tayo sa trial proper dito sa 3 counts of murder and attempted murder, crimes against humanity cases against former President Rodrigo Duterte. At the end of this confirmation charges, we are expecting a decision from the pre-trial chamber whether, confirming the charges or not. In other words, kung tutuloy ba sa trial or hindi. Balik po tayo doon sa arguments po or sa possible arguments ni Attorney Kaufman. Attorney, doon po sa intent, kasi yung nakita natin yung presentation so far ng victims at ng prosecution, talagang ginamit nila yung sariling words ni Duterte against him. And based on your analysis and based on other experts' opinion, basically they will try to disprove the intent. Kasi yun yung doon na lang naglalay yung kanilang defense. How would they do that? Can they do that given the breadth, given the weight of all the evidence presented? Kasi we're not just talking about statements, we're also talking about memorandum, we're also talking about, the patterns of killings. How can they disprove intent, if ever?
Again, the way Kaufman crafted the defense based on his opening statement, I don't think his audience is the court. I think they're trying to, the audience is the public. They're trying to destroy the credibility of the witnesses, the credibility of the court, and even that of the prosecution. Because if you look at it, they will, what they can do is to focus on the statements that will counter whatever public statements quoted and cited by the prosecution. However, when you weigh the evidence, you don't look at the evidence in isolation of the other evidence, because the relevance of the public statements or these public statements cited by the prosecution will be given relevance by the other pieces of evidence submitted by the prosecution. For example, the Command Memorandum Circular 16-2016, that memorandum circular will now give context to that pronouncement of kill, kill, kill. Because they said in that command memorandum, neutralize. And you will now jump to the Excel file where there is annotation on those killed, and they annotate it as neutralized, which is separate from the entry on when he was arrested. So if you take those statements in isolation, probably they can say that that's not the intent. But if you look at it in light of the other evidence, it will point to intent, and it will definitely prove that the intention when he said that is to kill these criminals, as they say.
How about you, Attorney?
I like the idea of the prosecution. They presented President Duterte as privileged, a lawyer, a prosecutor. In fact, he was a teacher. And also presenting some of the policies when he was a mayor and during his presidency and all these actions. And I agree with Attorney Cortez here when he mentions that the intention is difficult to counter, to destroy, especially when all these acts are obviously not only selected, but we can see the pattern, the system, how the architecture was made for these purposes. And I also agree with the statement that the audience here by the defense is obviously not only the ICC as a court, but also public opinion, the public, the supporters. And that's why the sound bites are very good, and we can expect more of that today, maybe on the, especially with the supporters very active right now in social media.
Yeah, that's why, as we called it, Kaufman's messaging and rhetoric was basically straight out of Duterte's populist playbook. Very, very, mirroring Duterte in essence. Just a follow-up on the intent. Is that why the prosecution was really confident when the prosecution said that even if you remove the speeches of former President Rodrigo Duterte, they can still establish the crimes against humanity because they have the memorandum, the witnesses. Do you think those evidence are enough to meet the threshold of substantial grounds to believe?
Yes, I believe so, because as they said, they have witnesses, they have insider witnesses,
Yes.
and they have public documents, and they have documents signed by Duterte, and they have the speeches, the public statements. So I think they have enough evidence, even if they will forego the presentation of the public statements. I think they have enough evidence to show the intent.
Yeah. Attorney?
Yeah, at the very start of the presentation of the prosecution, I was thinking that they will really have it. They will really have a difficult time in proving not only intent but the systematic and the widespread attack based on the definitions under Article 7. But with their presentations last 2 days, we can expect that it will really be a difficult time for the defense right now, and it's difficult to destroy all those evidence. Without the statements of Duterte, there are witnesses of victims, and there are also documents and some policy actions really that were presented.
We're going to read some of the comments from our Rappler app from the Justice and Crime chat room. This is from our user Sterling Herrera Shaw. This is a part of her comment. You can head to the app if you want to give your insights as well. This is her comment. Kaufman would use, of course, argued that Duterte's orders were literal orders. He has to because the entire case rests on it. No one can dispute the actual deaths. They are of record. So Kaufman has to try to convince people these killings somehow started without Duterte ordering them. He can't actually do that practically, though, since the literal national police was behind the vast majority of killings. He is responsible for their actions as president. So we are now minutes away from the scheduled hearing, the third day of the ICC confirmation of charges hearing. Again, today is Kaufman's day. The entire day, Kaufman, as the defense lawyer of former President Rodrigo Duterte, would be given a total of 3 hours today. That's divided into 3 parts to try to rebut the arguments raised or the submissions presented by both the prosecution and the victims. At this stage, ito po yung napapanood nyo po sa mga local trial natin. Ito na po yung dedepensahan na nung akusado. In this case, di pa akusado si Duterte, suspect pa lang siya. Pero dito, as early as this part, try na pong i-disprove ng lawyer ni Duterte yung mga alegasyon laban sa kanya. Mabigat po yung mga alegasyon sa kanya. So far as the prosecution is concerned, they believe and they, really confident that the elements of the crimes against humanity case has been met so far or have been met so far. So we are really looking forward to how Kaufman would rebut those presentations so far. Ngayon, mga attorney, another thing here is that yung mga co-perpetrators ni Duterte ay napangalanan na. In other cases, in other situations, ano po ba ang nangyari? Kasi ito yung question kasi ng mga tao. Some people really reacted, some violently, some enthusiastically, when the ICC prosecution named the co-perpetrators both on the mayoral and the presidential periods. In other cases po ba, usually, kailan po nagsisimula yung proceedings naman or investigations on the co-perpetrators? For example, in this case, Duterte, sa co-perpetrators niya, do we expect another investigation or isolated ba siya dun sa investigation solely for Duterte? Would there be, another investigation just for them? Ano po ba ang jurisprudence?
I think we have to remember here that he is being tried here for his individual responsibility and not the state responsibility. So all the co-perpetrators here identified should be tried for their individual responsibility. This time, it is the individual who is the subject of international law and not the state. So whatever evidence that may be against, for example, Duterte, and also with the other perpetrators, the same should be proven. And here we have to look at the evidence as presented and the participation of each one, so that their responsibility will be proven. Although we can see that in the systematic attack or the widespread attack to commit the crimes against humanity, all these persons have their own participation. But we have to look at them individually, and at the same time, their participation or active participation, direct or indirect participation as a criminal, an international criminal for this crime against humanity.
Attorney?
Yes. During the prosecution's presentation, if you look at the matrix that they presented, the core perpetrators, as they said, controls
is now in session. L'audience de la Cour pénale internationale
that were essential in the implementation of the drug war policy. So their responsibility
Please be seated.
there
Veuillez vous asseoir.
hinge on that control.
Thank you so much, Attorney Cortez. For the meantime, we're cutting our panel here to give way for the live feed from the ICC.
Bonjour à tous.
Good morning, everyone. I'd like to welcome everyone in the courtroom, as well as those who are listening in from outside the courtroom. Court officer, please call the case.
Good morning, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121-0125. And for the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, associate trial lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masida. Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman. Good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defence counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defence's submissions, I hope that they will at least communicate the following faithfully. The defence does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be levelled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defence's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defence's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defence's role is simply to persuade Your Honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So that police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you're presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, but if you do your duty, do not worry about cases. I'll protect you. Believe me, That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility. Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life. Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against a civilian population. With respect to the unique ICC requirement of an organisational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the Appeals Chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pre-trial chamber in the El Hishri case. And I do apologise in advance for the rather dull exposé which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10 February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pre-trial chamber, this same pre-trial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pre-trial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purpose of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the Pre-Trial Chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court. After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the Appeals Chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the one-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges levelled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defence has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive, of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee: at least more or less than 10 buy-bust operations. Where somebody was shot? Asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee: yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. the fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, VOW Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
Naputol lang panandalian ng broadcast ng ICC dito po sa third day ng hearing ng crimes against humanity cases ni former President Rodrigo Duterte. You are watching Nicholas Kaufman, the defense lawyer of the former president. And so far, ang ginagawa po ni Kaufman is to show that itong mga elements of the crime na ina-allege against kay Duterte, in other words, tinatry niyang i-convince ang pre-trial chamber, ang hukuman, na hindi ginawa ni Duterte yung mga alegasyon laban sa kanya o yung mga alegasyon ay binabato sa kanya. For the meantime, while we're waiting for the broadcast of the International Criminal Court, let's ask our in-house experts, anong assessments niyo po so far? Anong initial reactions niyo dun sa less than an hour speech ni Kaufman?
Well, as expected, he's nitpicking on the evidence cited by the prosecution. I think it's the only way that he can provide a defense for his client. Because if you look at the evidence as a whole, I think medyo mahihirapan siya. Very strong, very overwhelming, sabi nga ng ibang mga legal experts sa Pilipinas. So what he did is to nitpick. He treated it in isolation from the others, especially the speeches. And that is to insulate his client from any liability.
Ganun di ba assessment mo, attorney? As in, kumaga namimili lang siya ng portions of the presentations provided by the prosecution and the victims?
Yes, I agree. Because of the many evidence presented by the prosecution, he has to go to those items where he feels that he can be strong in its presentation by looking at and saying about others. So even with the concepts of self-defense and even the elements of the crime against humanity and all the elemental aspects there, they are just trying to do away with the facts, but they are doing their own interpretation. But if you look at, for example, the definition of widespread attack and even civilians here, the ICC has, for several cases, have established a flexible definition on that, not literal definition of those defined under Article 25, for example.
Yeah. For our viewers, What we're talking about here is the crimes against humanity cases, and that's the jurisdiction or within the jurisdiction of the International Criminal Court. That's precisely the reason why this case is at the ICC and hindi siya hinihir dito, because the ICC believes or the prosecution believes that widespread, malawak po ang pagpatay, kaya nagko-constitute daw yun ng crimes against humanity. Ngayon po sa mga kaso, may mga elements po na tinatawag na kailangan pong ma-meet ng prosecution o magpakita ng ebidensya ang prosecution para ma-meet yung mga elements na yun para makapag-convict or para mapakulong itong mga akusado or suspect po dito sa mga kaso. Ito po yung ginagawa ngayon ng prosecution. Kaya po nung nakaraang araw, nilatag po nila yung mga ebidensya nila para po inisa-isa nila yung mga elements ng crimes against humanity, katulad po ng pagiging systematic at organized at katulad po ng pagiging widespread. Kaya po iyon ang ginawa ng prosecution nung nakaraan. Ngayon po itong si Kaufman, tinatry niya pong i-question yung mga elements na yon. I think now we're back at the ICC. Nagbo-broadcast po ulit sila.
That on the very day that the former president appointed Ronald Dela Rosa Bato as the chief of Philippine National Police, Dela Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralisation of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. In writing, neutralisation as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralisation forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald Dela Rosa Bato within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, Dela Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that Dela Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defence, namely that the only use of force would be that envisaged by way of self-defence. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally. Go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, Maître, je vous remercie, Captain, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
You've just heard the submission on merits by lead defense counsel Nicholas Kaufman, at meron siyang binanggit na two major points why they are disputing the charges against former President Rodrigo Duterte. One is on the basis of the contextual elements of the crime, and the other on what he disputes as a non-proven criminal mode of liability, and I'll go through them in a bit. Nagbukas yung presentation ni Nick Kaufman by addressing journalists, and he says, if we were to cover this faithfully, he wants us to report that he says anything he will say today will not be a disrespect and taking light of the sufferings of the victims. Again, he hit media, journalists for salacious headlines, and these are criticisms we've received, or I have to say endured, during the 6 years of President Rodrigo Duterte's presidency. But let's go to the merits of the substantial merits of what he said. Una niyang inatake yung contextual elements ng crimes against humanity. And he begins by comparing it to the case of Khaled Mohammed Ali El-Hishri, yung Libyan official na naaresto na rin ng ICC. El-Hishri is one of the only 2 people ngayon sa ICC na magkakaroon ng confirmation of charges hearing. One of Duterte, the other is him, which is happening in the next months. Why was it important for Kaufman to bring this up? Nung nag-apply kasi ng warrant yung prosecution para kay El-Hishri, they defined the targeted or the attack population as those with an opposing or conflicting ideology to the Libyan government, kaya sila tinarget, kaya sila inatake. And when the pre-trial chamber issued that warrant, they made that distinction based on the application of the prosecution at sinasabi nila na yung mga detainee na nakadetain dahil sila ay migrant ay hindi natin isasali sa warrant dahil ang sinabi ng prosecution, ang kasali lang ay yung may mga conflicting ideology to the Libyan government. So after that warrant was issued, the prosecution appealed that definition, that narrowing of scope by the pre-trial chamber, saying that masyado daw limited yung pagtingin ng pre-trial chamber. So Kaufman brought that up and said, bakit naman i-appeal ng prosecution something that they chamber limited the scope of the civilian population na realized di umano ng ICC na baka makaapekto ito doon sa kaso nila sa kay Rodrigo Duterte at sa Pilipinas. And Kaufman was saying they don't want to impact one of the only 2 cases that they have. Kapag naapektuhan nung isa yung isa at dalawa lang sila, magkakaroon ng prosecutorial uncertainty. Kaufman was saying na very worried yung prosecution dito dahil kung if you were to apply the same logic on the El-Hishri case, on the Duterte case, sabi ni Kaufman ay maybe it will end up in a situation where the pre-trial chamber might find na hindi kasali sa civilian population yung mga inatake during the war on drugs and the Davao Death Squad because, as he says, drug suspects, suspected criminals, pushers are another subgroup of the population that may not end up being included in the scope. Kaya parang sabi ni Kaufman, the El-Hishri case is an inconvenient fly to the Duterte case. Again, inulit-ulit niya to at sinabi niya na the targeted population was selected randomly. Hindi siya yung talagang inatake intentionally at sila talaga yung target ng mga krimen. That was his main dispute in regards to the contextual elements of the crime. Second, when he discussed his disputes to the criminal mode of liability, Kaufman made it clear that for him, there has been no direct causal link from Duterte, as what he says, stuff that comes out of his mouth, to the deaths that we have seen in the street. This is very important because in crimes against humanity and in the ICC design, you have to prove a nexus. Paano mo papatunayan na yung sinabi or ginawa ni Duterte as an indirect or co-perpetrator directly resulted in the killing of one victim, for example, in any of the charges included in the charges of the prosecution. So para kay Kaufman, the prosecution cannot show a direct causal link from the words that come out of Duterte's mouth to the blood and the dead body that we saw on the street. Kaufman used the prosecution pyramid against them, and para sa kanya, causal link should be visually obvious. Tapos sabi niya, bakit yung sa prosecution a pyramid? So he said, and I quote him, not one of the incidents manifest such a causal link. And there's no smoking gun in this case. And sabi niya, ang nakikita daw natin is one kind of prosecutorial uncertainty. And he says, and I quote again, it's become increasingly apparent that with the absence of a direct causal link, that the prosecution has resorted to papering over the cracks with human rights reports, press statements, and Duterte's political hyperbole. And remarkably, in the last part of his submission on merits, he says categorically that the Davao Death Squad is complete fiction, disputing the integrity of the witness or the witnesses. In the Davao Death Squad context, he says na fiction lang daw yung sinabi ng prosecution na nagpamigay ng barel in baskets, na nagpaulan ng champagne. He says this narrative is quite preposterous coming from the insider witnesses. And he closed the first part of his opening statement by saying that the PNP CMC 2016 by Senator Bato, Dela Rosa, the criminal blueprint, allegedly, says the prosecution, could be negated by the content of the document itself, because when you read CMC 2016, it says to neutralize, but it also peppers a lot of legal stuff in there, a lot of constitutional stuff, but then in some paragraphs, lawyers would say unconstitutional din yung mali. And that is why the human rights lawyers who have been trying to declare the war on drugs unconstitutional on the basis of the list of this memorandum has been expressing disappointment time and time again na kung sana nagdesisyon lang yung Supreme Court noon pa dun sa kanilang mga petition attacking the legality of these documents, then the game could have been very different. The field in the ICC could have been very different. We are on break right now, and we'll return to you more when Kaufman goes to the second part of his submission on merits.
That was Lian Buan reporting from The Hague after Duterte's counsel Nicholas Kaufman presented at the Pre-Trial Chamber of the International Criminal Court. You're watching Rappler's special coverage of Duterte's pre-trial hearing at the International Criminal Court. Still with me are Attorney Efraim Cortez of the National Union of People's Lawyers and Attorney Rodel Taton, Dean, San Sebastian College, Recoletos Graduate School of Law. But now we are joined by Attorney Ross Togade, UP Law Senior Lecturer and ICC Assistant to Counsel.
In public, ever since he was the mayor.
Now, my first question, attorneys. Basically, basically Kaufman is now trying to, question the evidence or the presentations provided by the prosecution to establish yung elements of crimes against. Anong perspective nyo on Kaufman's response doon sa nanlaban narrative? Basically, Kaufman is saying na itong nanlaban narrative ay bahagi lang daw ng colorful narrative ni Duterte, at basically yung sinabi din si Kaufman doon na yung pag-i-impromptu daw ni Duterte sa kanyang speeches while mentioning these supposed kill orders ay hindi daw yung nagpapakita ng crafty design. Basically saying na hindi systematic or hindi organized yung killings. Ano pong perspective niyo yan? Let's start with Attorney Ross who is joining us from Australia. Attorney Ross.
Thank you, Jairo, and thank you, Rappler, for allowing me to join in this discussion. I think Kaufman was trying to do two things here. First was, he was trying to question the mental element, mens rea, as we know it in criminal law, which refers to the intent and knowledge. So the language in the statute is intent and knowledge. And then he's also trying to avoid any argument on causality. And yung nanlaban narrative feeds into this one, because he was citing those speeches. He was saying that, well, you see, he was actually ordering lawful means to subdue drug war suspects or drug suspects. But let me point out that under the framework of the Rome Statute, yung mental element, it doesn't, at least for crimes against humanity, it's the general mental element. It doesn't actually require a legal evaluation on the part of the perpetrator. So it's not even required for him to demonstrate that he assessed self-defense would be valid in this instance. So that was one way for Kaufman to argue na wala naman talagang intent. But intent and knowledge under the framework of the Rome Statute could be that evidence that he meant to engage in the acts that would result in the crime against humanity alleged. And in this case, that's murder. And we can see from inference, which is allowed in the ICC, that we can make that reasonable inference that there was intent in all of these speeches and pronouncements from the former president.
Just a follow-up question. When we say inference, what do we mean by that in legal terms? In more simple terms, kasi isa rin yan sa mga naging hot topic in the last few days. Wala daw inference or so far on the international jurisprudence as far as the ICC is concerned. What do we mean po by inference in this context?
So we have to clarify. I think this, as you correctly pointed out, Jairo, that some have been pointing out that inference is not allowed. Because of the nature of the crimes, we have seen in the ICJ jurisprudence. Of course, it's not international criminal law, but we do find the concept of inference there, which would allow us to make, reasonable ways of looking at and concluding that there are patterns, may non-repeating and non-coincidental ways of committing the crime. So in plainer language, to derive the idea na merong modus operandi na nangyari, that requires inference, and that is allowed in the framework of the ICC.
Thank you, Attorney Ross. Before I go to my another question, Attorney Kaufman mentioned, media using salacious content in reporting this. We take exception in that. Our reports are based on facts, based on evidence, and based on facts that we've gathered on ground. We've covered this in the last years, and they came from real people, and these stories are real from real people. Now, to my next question, another point of Attorney Kaufman in, refuting the speeches of former President Duterte. We are talking about that because malaking part ng presentation ng prosecution ay yung sa speeches. Apart from saying that hindi siya parang nagjo-joke lang siya, rhetoric lang yon. Basically, Kaufman is also trying to say na justified itong ginawa ng mga police because si Duterte himself said na gawin nyo lang yon kung nasa danger ang buhay nyo. In other words, kung nanlaban yung mga suspect. Ano pong reaction yun, Attorney F, Attorney Taton?
Well, he's trying to show that these policemen who follow the orders follow this exhortation of legal self-defense. But of course, that's a narrative that will not be supported by the evidence that the prosecution will definitely present. Because we have narratives showing a different narrative. That in fact, the nanlaban narrative is a reality. Yeah. That is what happened during the time that the drug war policy was being implemented. And there are also public speeches, public statements rather, where he said, kung walang baril, lagyan nyo ng baril. So, it's evident na yung legal exhortation to legal self-defense na sinasabi nila is just an afterthought para lang bigyan ng justification later on, yung kanyang kill order. In the same way na yung kanyang command memorandum circular, you use the word neutralize and yet you cite constitutional requirements and including RA 7438.
Attorney Taton, on the nanlaban, basically itong si Kaufman, in-echo niya yung nanlaban reasoning ng Duterte administration to justify the killings. What do you think of that?
I think that the accounts here are very clear, and not only the videos or statements of the victims, but there are actual incidences. And if you look at the statement earlier regarding the speeches of Duterte, maybe on the prepared speech it is different, but especially when he speaks from the heart can really express the intention there. And not only once, not only thrice, there are just a lot of statements from even before he was arrested. And I think these statements, especially those that are impromptu, are really from the heart, and that speaks of intent. And this is shown in the pattern and also on the orders. And all this, if we look at it, nanlaban is real.
Yeah. On the second point of Attorney Kaufman, he tried to question, that Duterte allegedly committed the elements of crimes against humanity. Basically, he discussed the contextual elements of crimes against humanity, whether they apply or not. Meron siyang attack on the, yung sa widespread daw. Hindi daw widespread kasi raw hindi naman daw entire population yung inatake, but rather targeted population, which happened to be, the alleged drug suspects, yung mga alleged drug personalities. Attorney Ross, I have a question on international jurisprudence. Nabanggit na rin kanina ni Lian, pero paano ba dinedefine itong widespread na to? Kasi pinag-uusapan din namin kanina off-cam ni Attorney F, Attorney Taton. Ano ba talagang definition dun sa widespread population? Attack on the widespread population, civilian population rather. Kailangan ba generic population talaga siya? Because Kaufman is trying to make it appear na yung drug war ni Duterte, hindi naman pang buong bansa yan, pang-addict lang yan. That's what he's trying to do. Anong tingin niyo po doon as far as the jurisprudence is concerned?
Okay. 2 layers here, Jairon. The first one is on the widespread and systematic nature of the attack. And the second one is the character of the civilian population. So I'll discuss those separately because there's a tendency to conflate widespread and systematic with the attack on the civilian population. So punta tayo dun sa widespread and systematic. In the ICTY or in the International Criminal Tribunal for the former Yugoslavia, there has been a discussion on what constitutes widespread or the multiplicity of the deaths that have resulted from the attack would already give us an idea of the widespread nature. So you always have to look at the figures in conjunction with the pattern. So if within a temporal scope, within a geographical scope, same mode of attack, multiple numbers of attacks, we can already assume na merong criminal pattern defined here as non-accidental repetitions of a criminal design. So I'll go to the civilian population argument of Mr. Kaufman because I think he did not mention on purpose kung ano yung language sa elements of crimes, which is another document aside from the Rome Statute. So it's a document that allows us to help our interpretation. Okay? And the evaluation of the evidence. So in the elements of crimes, if you read there in the text, it says, any civilian population. The word any there is not accidental. It's not a surplusage o hindi lang siya na ilagay lang nila by accident when they were drafting the elements of crimes. Any civilian population means any one part of the population. Okay? And just a bit of a history here, yung phrase na civilian population, we see this dun pa sa Nuremberg trials, the statute that established the Nuremberg trials. Civilian population there was understood in the context of the war. Pero nung na-transport na yung crimes against humanity in the present framework of the Rome Statute, civilian population here does not mean civilian population as opposed to a combatant population. So yung discriminating element that we use in war crimes, evaluating war crimes, we don't do that in crimes against humanity. So the term civilian population there would refer to the multitude, the people, the humanity, refer to the crimes against humanity tag of the crime.
Yeah, and as far as we are concerned here, then we're referring to, any Filipino who's covered by the memorandum, the 2016 memorandum of the Philippine National Police. Is that correct, Attorney?
Yes, that we can reasonably infer that interpretation, that it would refer to anyone who would be suspected of peddling drugs or using drugs, which at the time was quite arbitrary. So I don't think Mr. Kaufman was quite being accurate, to put it mildly, when he said there should be a discriminating element, for example, as opposed to how we evaluate it in genocide, targets of genocide or targets of war crimes. Crimes against humanity is a different legal regime.
Yeah. Attorney F, Attorney Taton, what do you think of that? Basically, Attorney Kaufman is trying to justify these killings by saying na, targeted naman ito, hindi naman to dun sa civilian population. He in fact mentioned that compared to the arrest, 6,000 lang daw yung killings. What a way to downplay these killings. What do you think of that?
As explained by Attorney Tugad, it's walang numerical standard.
Yeah.
Ang ano lang dun ay yung pattern. And I think nakita naman natin yung pattern, and I think the prosecution was able to establish yung pattern and yung number of killings, for example. And what they presented are emblematic cases that represent other killings that occurred during that period. And I think that's sufficient already. Siyempre, dina-downplay ni Mr. Kaufman yung ganong part ng evidence ng prosecution because he's trying to say na hindi pasok yung mga contextual element ng crimes against humanity dun sa case ni Duterte.
Kasi sinasabi niya parang kahit supporters niya are targeted here, but we look at the flexible interpretation of the civilian here, hindi dapat textual siya. So if we look at that, a segment of the population can be covered by the civilian population there, and at the same time the pattern, and kasi we have to look at the elements here as a whole, not simply as that, and as to the number, hindi naman kailangan na dapat 100 million agad, dapat ganito, ganyan. So it's not about the number, the pattern, and also the acts and the intention.
Baka hindi lang din po masyado nauunawaan ng ating mga kababayan. We have to explain yung term na indirect co-perpetrator. Attorney Ross, ano po ba ang importance or konteksto ng indirect co-perpetrator? Bakit po hindi natin tinatawag na mastermind si Duterte? This is a basic question for lawyers, but for our Filipino citizens, kailangan po nating ma-establish yun. Bakit po ba ang tawag natin kay Duterte dito ay indirect co-perpetrator at bakit po ba kailangan siya ma-establish?
Okay. So yung indirect co-perpetration na isa sa mga pamamaraan kung paano maging criminally liable ang isang individual under the Rome Statute. So we're saying indirect perpetrator because obviously he did not directly commit the crimes. He himself did not pull the trigger, or he himself did not do the killing. But the nature of crimes against humanity and international crimes in general, more often than not, meron kang criminal enterprise. So this was the older term in international criminal law, the criminal enterprise. So hindi na yun na-transport sa Rome Statute, but that assumes several people, sometimes or more often than not, a hierarchy. And yung indirect co-perpetrator, kasama o katuwang ng iba pang mga individual, they came together, created a plan, or created a system by which to execute the crimes. So babalik ako actually doon sa naunang punto ni Mr. Kaufman na his speeches cannot actually prove that he would be liable, or his speeches do not prove that he ordered the killings. But in evaluating evidence in international crimes investigations, tinitignan din natin, or we also look at the evidence of planning, the evidence of designing the system, and the evidence of how do you carry out the actual perpetration. Okay? So hindi lang yung ano ang nakita natin sa media, because behind closed doors, there could very well be evidence of that planning. Okay. And then I also would like to point out that indirect co-perpetration is one of the modes of liability. Pero the document containing the charges also refer to ordering and aiding, or aiding and abetting. So aiding and abetting would only require, number one, knowledge of the crime, and number two, some intentional conduct or purpose that would constitute participation or helping out in the criminal design.
And if we go by that, premise, na-establish naman locally that Duterte actually in fact used, state resources to aid in the supposed killings by providing rewards, financial incentives to these police on top of using, the budget of the DILG and the police to fund these supposed operations. Now, isa rin po, Attorney Tato, Attorney F, isa sa mga sinabi ni Attorney Kaufman to justify itong common plan, to refute itong common plan na pinapakita, in-establish ng prosecution ay itong common plan naman daw kasi ay, sinuportahan ito ng mga Pilipino. Basically, they voted Duterte. So, if this is the common plan, why did the Filipino people vote Duterte who had this supposed common plan in mind? Anong tingin niyo po doon?
A common plan that support or the commission of a crime can never be validated by the electorate. If it requires the commission of illegal acts, especially against civilian population, it's always illegal, and it cannot be violated by a vote of the majority. If the proponent is voted into power by a majority of the Filipino people, that will not validate that common plan. It remains to be illegal.
Yeah. Because we are still a country ruled by law, no? So kahit na binoto po natin siya, and that's one thing. And we also have to take note here, the organization and control of the organization, and the planning, the policy, and all this architecture that not only him maybe in forefront, but the entire scheme is clear, no? And kahit na suportado siya ng buong mamamayan and these actions, I think that hindi mawawala ang crime.
Dagdag ko lang, Jairo, no? Yung Holocaust, when it happened in Germany, it was supported by the German people. Pero it does not justify the commission of the Holocaust.
Yeah. Attorney Ross, do you have anything to add to that?
Siguro may dadagdag ko na lang, usually in these sort of crimes, international crimes, when it's committed by the state organ, you will always see this kind of support because it's the state organ. It's the state organ, but that doesn't mean, as correctly pointed out, it doesn't mean that it invalidates or erases the illegal nature of those acts. Simply saying, wala po tayong condonation doctrine sa ICC that erases the illegality of the acts.
And I think he's not being tried here for the state responsibility, but for individual responsibility. And I think yan ang alalahanin ng mga bawat Pilipino.
Kaya nga the other day, the prosecution presented, the list up to, I think, JK of the individual criminal responsibility, alleged criminal responsibility of the former president. Now, another question, dun sa word na neutralization, this has been, a hotly contested word in the past years. For context, the Memorandum number 16, series of 2016, contained the word neutralization, and the lawyers from the Free Legal Assistance Group questioned the legality of that memorandum, basically asking the Supreme Court to actually define neutralization. For us covering these drug war killings, neutralization means to kill, and that is also the interpretation of our lawyers and human rights lawyers. Now, ang sinasabi doon kasi, yung neutralization daw ay parang depende ngayon sa interpretation yun kasi wala tayong local interpretation. Now, my question is, paano po sana nakatulong, although local jurisprudence siya, paano sana nakatulong kung nag-rule na sana yung Supreme Court on those petition and actually defined the word neutralization in this case of Duterte? Attorney F, Attorney Tatan, then Attorney Togale.
I think mas maganda sana pag na-rule na declare unconstitutional if the meaning as written, na kasi minsan ang mga abogado tinitingnan natin dito and ini-interpret kung anong nakasulat sa batas, and neutralize may be subject to interpretation, and this is vague or subject to multiple interpretations, and it's problematic, especially when used for law enforcement.
Ang pagtingin ko dyan, when you consider the meaning of neutralize sa context ng case ni Duterte, you have to look at the evidence so far summarized by the prosecution. And there you can already see what it means, what neutralization means sa mga documents nila. Of course, they presented the command memorandum circular where the word neutralization is there. Then they presented the lists where the word neutralize also appears with a date. Now, with respect to Paruhinog and Espinosa, the date of neutralization is the day they died, and the day of their arrest is entered in another detail. Now, if you look at it if you look at this evidence, you can already see that what neutralize means. If you interpret the word in the CMC, it means killing. It means you neutralize, you kill, because that's reflected already in the documents. Because when you try to define neutralize from the context of this prosecution, you will look at the evidence, and the evidence will show you that what they meant is to kill.
Yeah. Attorney Tugade?
Yung word na neutralize could figure when it comes to evaluating first the common plan and then second the intent. When it comes to the common plan, as correctly pointed out, that neutralization, pag tinignan mo yung existing documents, for example, the death certificates, death certificates, cross-check that with the dates of the alleged neutralization, that could already tell you that within the common plan, how did the co-perpetrators interpret the word neutralize? And again, this goes back to my point earlier that we also evaluate in crimes against humanity case build-up, evidence not usually peer into because these things happen behind closed doors. So that is already evidence that we can make an inference of. So this is where also where inference also figures in that neutralization was actually or actually had a very specific meaning within the common plan. Now on intent, neutralization, look at it from the perspective of ano ba yung inintend nila when they said neutralize, and then you look at the chain of events or you look at the pattern of events that happened since the order of neutralization was given, or since the word neutralization appeared in policy documents. Again, inference, which is allowed in the ICC, would tell us that, hey, neutralization actually means killing. So neutralization here, when you tie all the pieces together, pull all the strands together, can figure into the common plan and figure into the actual intent when they were using the word in the context of the police operations and what it resulted in.
Thank you so much, Attorney Ross Togades, UP Law Senior Lecturer and expert on international law. Thank you so much, Attorney.
Maraming salamat.
We're just waiting for the ICC to start their feed again. We're waiting for the second part, for the second of 3 parts of the presentation of submission of merits by Duterte's defense counsel, Nicholas Kaufman. Just last one question, Attorney, for the meantime. Question ko lang before while we are still waiting for the feed. Ano po bang i-expect nyo ngayon on the second part? Do you expect Kaufman to now attack the jurisdiction? Kasi hindi niya masyadong natutukan the first part. Do you now expect him to discuss jurisdiction? Kasi ito yung isa sa pinakamabigat nila na defense. At kung titignan natin, montek silang manalo on this issue on the jurisdiction, at least on the pre-trial, at least on the appeals chamber, 3-2. Hindi ito unanimous. Ano pong in-expect nyo?
And I think we expect that, and they have been consistent on questioning the jurisdiction of the tribunal. In fact, they're still consistent with the kidnapping argument. So we look at jurisdiction in 3 main aspects. One is on the person of the accused or the suspect here in this case, on the time elements as to the time when the alleged crimes were committed, from the Davao Death Squad while he was mayor and until the time that he was president, and from the time of membership of the Philippines to the Rome Statute up to the withdrawal, and also as to the subject matter, really, as to the definition of the crime. And we expect that they will continue with this kind of argument and maybe, again, more appeal to the Filipino population, especially to the supporters.
Well, they will definitely pound on the issue of jurisdiction because they do not want to go to trial. They don't want the prosecution to present their evidence, because what we saw here is just a preview of what are the evidence for the prosecution. When they go to trial, you can now hear the testimonies of witnesses. You can now look at documents that the prosecution relied on to prosecute Duterte. So they don't want to do that. That's why they will pound on jurisdiction. They don't want to go to trial, and that's the only way for them. That's their only way out for him.
For our viewers at home, ang ibig sabihin po ng jurisdiction ay kung saklaw po ba o sakop po ng korte, ng ICC in this case, si Duterte po bilang isang individual o yung mga allegations laban sa kanya. Basically, ang gusto pong mangyari, bukod sa nangyari nila Duterte dito, na dinggin ang mga allegation laban sa Our problem here kasi is highly contested yung resumption kasi kung when nag-acquire talaga ng jurisdiction yung ICC or kung may jurisdiction ba siya in the first place. Kasi ang argument ng camp ni Duterte, bakit nag-start kasi yung formal investigation after Duterte left left the Rome Statute, basically left the International Criminal Court. But sabi naman ng prosecution, hindi, may jurisdiction yung court kasi may preliminary examination na nung umalis si Duterte. Ano pong pananaw niyo doon?
Kasi if we discuss jurisdiction, sa pagkaintindi natin sa international law, may tatlong klaseng jurisdiction here, especially for this crime, under the Rome Statute. Jurisdiction as to time, halimbawa, yung sinasabi natin from the time of the joining of the Philippines up to the time of withdrawal, pero clear kasi doon sa Rome Statute mismo na kahit na mag-withdraw ang Pilipinas sa Rome Statute, sa acts covered, magkakaroon pa din ng jurisdiction ang court, And also as to the subject crime, subject matter na jurisdiction naman, ang kaso ngayon is crimes against humanity. So ang mga acts ba na constituting these crimes against humanity were committed from the period kung saan ang Pilipinas ay part ng Rome Statute up to the time na nag-withdraw. And also, while they are still questioning on the jurisdiction over the person, especially with the allegations of kidnapping, so walang jurisdiction over the person. So, but this is also resolved within the context of the International Criminal Court, the Rome Statute, especially when the jurisdiction over this person was acquired through arrest,
Yung ICC kasi, although they have several divided into several sections, so you have the Office of the Prosecutor, the Pre-Trial Chamber, the Trial and the Appeals Chamber. This is the ICC as a whole.
Yeah.
So when the Office of the Prosecutor started the preliminary examination in 2018, that's the start of the investigation. Not when the Pre-Trial Chamber authorized the conduct of the investigation after the preliminary investigation. No, the reckoning point there is when the Office of the Prosecutor started the preliminary examination, because OTP is part of the ICC. So it's not unlike in the Philippines where you have the City Prosecution Service, which is different from the judiciary. Here they are part of the same court, but performing different functions.
Yeah. We are now live again from the ICC. So supposedly kanina private or closed session ito.
Issuance of PNP.
Now we are watching the resumption of Kaufman's presentation on the merits,
which set out additional policies and guidelines in the conduct of double barrel. This directive instructed investigative units on how to perform their responsibilities in the case of armed confrontation during the implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01/21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald Dela Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, Dela Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which Dela Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of Dela Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which Dela Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, The term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
If I may, Madam President, of course.
Thank you very much.
I thought we had an understanding with the learned chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald Dela Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with Dela Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit. He excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief, none of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
Naputol lang po panandalian ang stream ng ICC Pre-Trial Hearing dito sa crimes against humanity cases ni former President Rodrigo Duterte. Nicholas Kaufman, the defense lawyer of the former president, is currently in the middle of the second part of his presentation on the merits, submission on the merits on the pre-trial chamber. So far, he's mentioning the neutralization once again. He's claiming that there are no judicial records in the Philippines mentioning or defining the word neutralization. And aside from that, he also mentioned that in the interview provided by the prosecution, or the interview by former Justice Secretary Vitaliano Aguirre II, one of the co-perpetrators, in that interview, sinasabi ni Kaufman ay meron naman daw doong part na sinasabi na justified naman daw yung killings dahil hindi naman daw aarestuhin or aatakihin kapag unarmed or kapag armado lang daw yung atakihin. And aside from that, on the latter part of Kaufman's presentation is basically creating doubts on the individual criminal liability of the former president. Now we're back at the chamber.
Concerning and coming to the ninth category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by Dela Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not Dela Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. in furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realise, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure therewithout. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organisation referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001-2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001-2376 -R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
Again, meron pong delay may delay po dito sa pag-live po o doon sa transmission po ng feed ng ICC mula po doon sa The Hague. Si Kaufman po ay nasa kalagitnaan. Actually, patapos na po siya sa second hour ng kanyang presentation on the submission of the merits. Bago po siya na-interrupt nitong ICC feed, siya po ay pinapakita niya na naging rhetorical na siya actually dun sa kanyang mga statements. Instead of citing mga specific evidence or presentation or merit, ay naging rhetorical na siya. Gumagamit na rin siya ng mga false causality o ng mga bagay na hindi not necessarily legal, but beyond that, minimension niya rin yung konsepto ng conspiracy. So while gamitin po natin yung pagkakataon to talk about that, bakit po kaya minimension ni Kaufman dito yung conspiracy? Conspiracy is basically different from, co-perpetrator na tinatry na concept na tinatry na establish ng prosecution. In this case, bakit tinatry ni Kaufman na i-bring up po yung conspiracy?
Well, stricter ang requirements pag sinabi mong conspiracy because in conspiracy, lahat ay criminally liable. This is quite different sa concept ng indirect co-perpetration at saka ng direct co-perpetration because the indirect co-perpetration can be held criminally liable even if the co-perpetration are not criminally liable. Because what you simply need to prove is that the co-perpetrators are part of the plan. They designed the plan and part of the implementation. In this case, as laid down by the prosecution, the co-perpetrators were appointed by Duterte to key positions in Davao and later on in the national position that gave them control over the structures that were used as the structures used in their anti-drug war policy that resulted in these killings.
Taton, sa conspiracy. You mentioned earlier, the problem here is we have different definition of conspiracy depending on the jurisdiction.
Sinabi niya mismo that sa kanila, bilang iba ang sistema nila doon, no? Dito sa Pilipinas, iba din, no? And common law jurisdiction as distinguished from our kind of jurisdiction. And also you have to look at the jurisdiction of international law, and particularly the Rome Statute that defines a co-perpetrator, indirect co-perpetrator, in this case of Duterte, for example. And there are clear definitions there that are not within the domestic jurisdiction. The domestic jurisdiction can be very strict, especially when they interpret and look at, let's say, conspiracy as a crime. Because everyone should have contributed, they should have come together, and absent any act, there will be no crime at all. No? But here, as you said earlier, we are looking at the individual responsibility and the indirect co-perpetrator. The acts of the indirect co-perpetrator can be seen in the organization, in the control, in the systematic architecture of this kind of acts, in such a way that even if the other co-perpetrators are not presented, here the crime of Duterte, for example, can be established by just him being presented in court. In conspiracy, if you cannot present the other conspirators, you cannot prove the entire crime, and there is no crime at all.
Before we go back to conspiracy, let's discuss first this transmission of the International Criminal Court. Before the live was interrupted, we can deduce that Attorney Kaufman was actually reminded, by the chamber not to mention the public redacted information. Bakit po ba may mga ganung publicly redacted version of documents? Ano po bang purpose nun dito sa pre-trial hearings na to? Kasi, di ba, in one of their petitions, they tried to, name yung mga witnesses. May mga ganung motion itong si but then again, hindi sila pinayagan. Now we're back again at the chamber.
Answer later.
Let's try to answer that later.
Randomly grabbing and killing, just so that there would be something to report on TV for the one-time, big-time operation. Now, I ask you, How can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? It's the prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Khoshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration, from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006-0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamouring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention centre? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
We've just witnessed the second part of Kaufman's presentation or submission on the merits of Inda Duterte's pre-trial hearings at the International Criminal Court's Pre-Trial Chamber 1. For now, we will have our senior investigative reporter, Lian Buan, who's covering the pre-trial hearings at the International Criminal Court. Lian, what do you have for us?
Jairo, you've just heard Nicholas Kaufman use the Supreme Court's inaction as a boost to their case. He mentioned repeatedly that the Supreme Court has not to this day acted on the two petitions declaring seeking to declare the war on drugs unconstitutional. These were petitions filed by Center Law and Flag. The Center Law lawyers are now the victim's lawyer. At sabi ni Kaufman, the Supreme Court's treatment of this case is instructive. So he's saying that if the Supreme Court has not to date found that neutralize meant to kill, or that there was anything wrong with the circulars of the Philippine National Police, then it's instructive that maybe nothing is wrong with a war on drugs. Kaufman also cites succeeding circulars of the PNP that corrected the errors of the PNP CMC 2016. We've reported on this years back. There was a study by the Ateneo Human Rights Center that found that after the scrutiny or the uproar against CMC 2016, the Philippine government, through PNP, PDEA, and DILG, sought to really correct the errors of these circulars through succeeding circulars in a bid to cover legally the flaws of the drug war. And then Kaufman ended with citing the statistics of the UP Third World Studies Center, the HAS project, that finds that there continue to be killings under the Marcos administrations. In fact, there are some months that it's in equal frequency as with the Duterte government. And he asks, why is anyone not investigating the Marcos killings? I had a very brief conversation with Attorney Nery Colmenares during lunch as we went on break. And I asked him if there's anything with what Kaufman said that concerns him or he finds, as a lawyer, objectively, that he finds beneficial to the defense. And he says yung impression niya that Kaufman's strategy so far has been to find the flaw in the prosecution rather than to present their own witnesses or their own arguments to support na walang widespread policy of killings si Pangulong Rodrigo Duterte. Jairo.
Lian, kamusta yung dyan? Kamusta yung demeanor ng mga families? Because the families, the relatives, the supporters of these victims are watching. And ano ang mga naging reaction nila dito sa mga statement ni Kaufman, basically justifying the killings further, questioning, everything. Diba sinasabi niya pa na hindi naman daw ganun ang ibig sabihin ni Duterte when he said na patayin, and that yung mga nanlaban na ito ay pinatay lang naman because they were armed and the police were just defending themselves. Anong reaction dyan on ground?
I also heard si Shira Escudero, like the most targeted and harassed and attacked victim here in The Hague. Parang sinasabi niya kanina na she heard Kaufman say that there's really no common plan. Taba narinig natin, diba, si Kaufman, sabi niya, there was no meeting of the minds between these people and the core perpetrators. There's no common plan to kill. So narinig ko si Shira, sabi niya kanina, kung walang common plan, anong nangyari sa kapatid ko? Referring to Efraim Escudero, who was killed when he was 18. Kaka-break lang kasi din namin. So, nagde-debrief pa yung mga victims and their lawyers and the human rights advocates at pinag-uusapan pa nila kung parang pinaprocess pa nila yung sinabi ni Kaufman kanina.
Lian, in your experience covering the justice beat, you've been following this issue, the drug war issue, since for a long time. Meron yung sinabi ni Kaufman justifying itong sa neutralization, that the errors in the 2016 memorandum of the Philippine National Police, the efforts there to correct the supposed questionable orders there. In your case, as a person covering this, did it really correct the flaws of the 2016 memorandum? Speaking from your experience, Lian.
Well, we do know that people continued to be killed even after those circulars were corrected. Unfortunately lang for the victims who were killed and their families, naputol kasi yung coverage area ng ICC after 2019 because that's when the withdrawal became effective. But we know for a fact that people continued to die and people continued to be killed after those circulars were corrected. And as we know, the Duterte government, especially the PNP under Bato, would temper and then would say, oh, the war on drugs is back in its original strength. Tapos ite-temper na naman and then going back na naman. The dead bodies on the street and the funerals speak for the fact that after those circulars were corrected, may mga namatay pa rin.
Yeah, and from 2016 to 2022, the estimations of human rights group, actually 27,000 to 30,000 people were killed under Duterte's drug war. Last question from Milian before we let you go. During the transmission or during the second part of Kaufman's speech, merong mga nawawalang parts. Actually, dito sa stream ng ICC, bigla na lang no broadcast. Meron ka ba idea kung bakit we have, we can deduce that it probably because, he's mentioning publicly redacted information. Meron bang relationship doon? Meron ba kayong information dyan? Na-brief pa kayo dyan in person?
Actually, dahil nga 30 minutes delayed kayo at the rest of the world, kaming mga nanonood sa gallery, we haven't had the chance to see kung ano yung hindi pinakita sa inyo. But just to give you an idea, there are 2 layers of closed session. So I understand that from day one, during the opening statement, yung part ni Kaufman about the disqualification of Karim Khan, I understand hindi niyo yun napanood at length. We were able to watch that at length, and I can say that Kaufman was detailing 3 witnesses during that part na hindi nyo napanood, pero napanood namin. Kanina, first time naming na-experience na pagpasok namin sa gallery at nakabukas na yung kortina, nakikita na namin si Kaufman na kinakausap si Judge Motok, hindi rin namin marinig. And we were all frantic in the gallery, baka merong mali dun sa headphones namin. And then we were reminded by the guard that there really is no sound because it's a closed session. Pero hindi ko alam kung ano yung niredact pa sa inyo. But I'll go ahead to say that Kaufman dedicated a good portion of his second segment by discussing witness P3. So ito yung code ni P3. These are not Davao Death Squad witness. This is not a Davao Death Squad witness. This is a witness in the war on drugs who testified that the list was a kill list. He testified that they killed assets and informants kapag malapit ng kumanta. He testified that his targets was selected for him, informed by a kagawad. He testified that pag meron ng target yung kagawad, a riding in tandem would be arranged. Kaufman said this because he was saying, yun bang CP3 witness ba? Was he acting on a criminal plan that came from the mouth of Duterte, or was he acting on the whim of the barangay chair? Yun yung kaninang sinasabi ni Kaufman, if you heard that or not.
Yeah, thank you so much. That's our senior investigative reporter, Lian Buan, reporting from The Hague, Netherlands, as she covers the pre-trial hearings of former President Rodrigo Duterte. Thank you so much, Lian. Now, let's go back to our panel here. Our experts at the Rappler Newsroom may mention doon si Kaufman at the end of his speech. Basically, he cited Rappler and DAS Project. The DAS Project, for context, is the independent monitoring of the UP Third World Studies. They've been monitoring the drug war killings from the time of former President Rodrigo Duterte up until now. And basically, what Kaufman is trying to say here is that why fallacy na po. Bakit daw puro yung kay Duterte lang yung titignan kung nagtutuloy-tuloy pa rin naman daw yung patayan kay Marcos? But we have to correct that. Actually, according to the data of UP Third World Studies Center, mas marami pa rin pinatay. Nagtuloy-tuloy man ang patayan under kay Marcos, incomparable pa rin yun compared doon sa bilang ng pinatay sa ilalim ng administrasyon ni Duterte. Under Marcos, around 300 ang pinatay from on the first year of Marcos, whereas kay Duterte, umabot tayo sa nearly 30,000 in his 6 years. Now, let's go back to our panel. Ano pong pananaw nyo doon? Kasi parang hindi na legal argument yun eh. Fallacy na siya.
Regardless if you monitor the deaths during Marcos period or you do not file cases against the perpetrators, that will not affect the criminal liability of Duterte for the crimes committed while he was president. So that is not a defense to exculpate his client.
Yeah, because the period here has to be remembered as to the time that the Philippines is a member to the Rome Statute. No? So, and not this time when we left the Rome Statute already. So it's irrelevant, and at the same time, we can clearly see that the goal here of the defense lawyer is to just incite the public to have a very good soundbite probably or something. But as regards the defense, I don't think that it has actually destroyed the evidence as presented by the prosecution.
Now, for the meantime, let's go back to The Hague, Netherlands. We have our Rappler correspondent, Michelle Abad. Michelle?
Hi again, Jairo, coming to you from outside the ICC. Right behind me, you will see some Duterte supporters gathering. As usual, may pahanda na konti, may mga pagkain sila every day. Today is a little bit of a lighter mood, especially ngayon, araw ng defense. Ever since, diba, from the past days, ang nakafocus ang allegations from the prosecution and from the victims. So ngayon, araw ng defense at may mga Duterte supporters na lumabas today. Ako personally, naka-witness ako kanina habang first sessions, may mga pro-Duterte Filipinos na nanonood ng live stream. May mga vloggers dito na live din nag-react sa mga sinasabi ni Attorney Kaufman. It was, of course, an affirmation of what they already have been standing for. So, kanina, mas konti yung tao. I've heard na may trabaho kasi. So I think yung iba dito ay took time off of work para makalabas dito. At ayun po, so mas na ngayon, mas light ang mood ngayon, especially after the first two sessions. So I have with me Alvin Sarsate, who is one of the Duterte supporters here. We will interview him for a little bit. So, Sir Alvin, can you come into the frame? Naka-live po kami ngayon.
Hello.
Yes po. So, can you, I can just hold it for you, sir, and then if they have a question, I can tell you. So, sir, pwedeng konting reaction lang po sa mga naganap po so far na sa hearing po kanina.
I think Attorney Kaufman really did a brilliant job, and he managed to refute all of the allegations hurled with respect to the presentation of the prosecution. I really believe that he did a splendid job also revealing that the document that was presented by the prosecution was the same document refuting their arguments. Overall, we are hopeful that the result of the judges with respect to the confirmation of charges hearing will end up favoring the former president, ultimately dismissing the case.
I observed you po kanina, in the beginning when you were broadcasting to your followers habang nagsasalita si Attorney Kaufman. What can you say about the reactions po na lumalabas po sa vlog po ninyo?
Well, for me, I was being emotionally vested in the entire proceedings. I really liked how Attorney Kaufman stresses the inaccuracies of in as far as the prosecution's presentation of the arguments are concerned, and I really like that he was able to uncover and show to the international community that this is nothing but rehashed peddled allegations, which has already been utilized by the detractors even before the time of the former president as president.
Okay. For the panel po, may tanong po ba kayo kay Sir Alvin?
Michelle, I only have one question for Sir Alvin. So, and after that, we can let him go na. Just a question. Naniniwala ba sila na despite, the breadth, the weight of the evidence presented by the prosecution, talagang itong confirmation charges ba ay hindi mangyayari? Are they hopeful na, the pre-trial chamber would rule that Duterte or the trial against Duterte would not happen or will not happen? Michelle?
Okay. Sir, following the evidence presented by the prosecution, do you believe that the confirmation of charges will not happen or go to trial? What do you think, sir?
I am hopeful that it will not push through trial, but noting all of the developments with respect to the case of the former president before the International Criminal Court, I think there's really an intent for all of this to push through trial, and that if they're really going to embody what they perceive as the International Court of Justice, or being the Hague, the center of international justice, and they are anchoring everything with respect to deliberation doon sa batas, then they should dismiss it outright. But however, if this is going to be revealed as one of the politically motivated attacks on the Dutertes using the International Criminal Court, then most likely it will push through trial.
All right. Thank you very much, sir.
Yeah, thank you, Sir Alvin. Michelle, just last one question. For you, what are we expecting in the next hour? Ito bang mga supporters ni former president? Would they still, hang around there? Papanoorin ba nila yung last part ng, last part ng presentation? Itong merits, Michelle?
So far, since coming out of the break, wala pa naman ako nakausap na sinabing tututok sila sa live stream. Pero may mga nakausap naman ako dito na hindi naka-follow dun sa unang mga session kasi papunta pa lang sila dito. So they're hoping naman na makapasok sa public gallery na makanood ng live. But maybe just before I go, we also chanced an interview or a quick interview with former legal counsel Salvador Panelo when he went outside, and he also said that quote, Attorney Kaufman did not disappoint. So it's a good mood out here for the pro Duterte Filipinos, and they're expecting siguro a better performance in the next session.
Yeah, thank you so much, Michelle Abad, our Rappler correspondent who's also covering the pre-trial hearings of former President Rodrigo Duterte at The Hague, Netherlands. Thank you so much, Michelle.
Thank you, Jairo.
Yeah, let's now go back to our panel. Last few questions for our panel. Again, I'm going back to my question. Kaufman mentioning the drug war deaths under Marcos and all that. The problem there is that Kaufman also tried to refute, the interview of Aguirre's interview provided by the prosecution on the other day, whereas in-interview si Aguirre ng isang media network about these supposed killings, and then Kaufman is now trying to say that this is, a nitpicking again on the part of the prosecution. What do you think of that? Ito bang nitpicking strategy ni Kaufman so far in your assessment, Attorney Cortez, Attorney Taton? Nagwo-work ba ito? Kasi nabanggit nyo na rin kanina, doon sa plethora of the evidence, ang ginagawa ni Kaufman, instead of really addressing the major and the focal points of those arguments, namimili lang siya ng kanyang sasagutin. Anong pagtingin nyo doon?
I think that's his role, to really select and state for the record that the evidence of the prosecution is poor or not adequate enough to proceed to the trial. And that's basically his goal, no? And sa mga pinipili niya na mga ebidensya lang, and even statements like Aguirre and all that, he's off there to destroy the evidence of the prosecution, although very limited, and not all the entirety of the presentation of the prosecution was destroyed or countered, especially because, of course, selected. But if we look at the entire speech and presentation of the defense lawyer here, again, the audience is the court and the audience is the public. I think that's one thing notable for me.
Look, if you look at the fact that he is addressing the court now, the court is presided by three jurists who knows the law.
Yeah.
They all know the law. So you know what the Kaufman is trying to do. Well, he was able to do a job pleasing his client and his client's supporter. But definitely, he was not able to weaken the evidence for the prosecution, because in questioning the evidence for the prosecution, that's evidentiary and legal. What he did is far from being evidentiary and legal. He's there to perform for Duterte and his supporters.
Yeah. Another thing that we, witnessed in the last few days is the mention of the third witness of the prosecution, P3, basically the third witness. In the get-go, we all know about the two witnesses which are Arturo Las Cañas and Edgard Matobato. They are self-confessed members of the Davao Death Squad. If we're going to look at their testimonies, their affidavit submitted to the International Criminal Court, majority or all of their testimonies and their affidavit actually discussed the supposed killings under the Davao Death Squad, which which don't cover the killings on the presidential period na kasama doon sa count 2 and 3. But yet again, here's the prosecution saying na actually we have a witness who will testify or who testified about the presidential killings or the killings under the presidential period. Paano po nakakatulong ngayon sa prosecution na nakakuha sila ng ganit, aside from testimonial evidence that they have, the memoranda, other written proof and evidence, speeches of the former president. Now they have a witness who testifies about these supposed killings on the presidential period. Paano po yun nakakatulong dito sa kaso ng prosecution?
If this witness could testify on how the orders were being given and how it is being carried out, if the presentation of the prosecution regarding the supposed chain of command that referred to by the third prosecutor, the last one who presented. If I believe that chain of command that they presented is based on the testimony of this third witness. So he or she probably has knowledge of how the system works, especially they mentioned about the reward money. You can deduce from the presentation that this is based on an insider witness, and I think it's very, very strong evidence to further establish the nexus between the crimes committed and Mr. Duterte.
Just in relation to that, I noticed a statement on express contribution. In fact, he cited this case of prosecutor where prosecutor versus the last case that was mentioned, 2025, the Darfur case, where there was guilt found by the court. And there, we should not just consider the concept of conspiracy and the direct participation, but here the element of control is very important. That the pattern of, and also not only the pattern, but the control and the policy architecture as a whole. So the control and the character of Duterte as the president of the Republic of the Philippines will show that he is the person in performing the important character here. No, and so there is a very clear contribution, especially when you speak about the testimony of P3. No. And also as established, like let's say the model of the Davao Death Squad, and as brought to the national level, and all this scheme, the architecture is clear that it has some basis, and also the uniformity of the procedure, and with the entirety of the presentation of the prosecution, this character, the control, and the participation is clear. Although, again, under Article 25, they're indirect co-perpetrator only. Yes.
Ito pong, again, to our viewers, in this stage of the ICC proceedings, we're currently at the pre-trial stage, and what the pre-trial chamber is looking for are submission, merits, pahapiaw, patikim na ebidensya that would establish substantial grounds to believe that crimes are committed before, and if the pre-trial chamber nakita yung substantial grounds, mag-move forward tayo sa trial kung saan ipapakita talaga yung full-blown na mga investigasyon or full-blown evidence na meron ang prosecution at itong victims. Doon po sa definition natin ng substantial grounds, kasi medyo iba kasi to doon sa Philippine jurisdiction. Kasi sa atin po, para tumuloy sa trial, probable cause. Tama po.
Certainty of probable cause.
Certainty of conviction, probable cause. Yun yung threshold or requirement na ginagamit po ngayon as evidence, sa quantum of evidence po. And then sa court mismo, yun na po yung proof beyond reasonable doubt. Same pa rin naman sa ICC. Pero sa definition, sa ibang jurisdiction, sa ibang cases po, dito sa mga international cases like this, paano po ba na-measure yung substantial grounds to believe?
Here, the substantial ground that is required for the pre-trial stage or the confirmation of hearing, it's more than speculative, more than speculation, that there is a credible and substantial evidence that can proceed to the trial, that can be supported by the full-blown trial. So that's just the enough grounds to warrant that there is credible evidence. At the same time, hindi siya yung magic lang na based speculations.
Attorney,
it simply means that there is an adequate evidence to support the charges.
Yes.
So it's not about whether a crime has probably been committed, like probable cause here. It's less than probable cause, because as long as it is sufficient to or adequate to support a conclusion, that's you already was able to meet the threshold, evidentiary threshold.
And going by that, threshold, that is basically the threshold of the pre-trial chamber, and without preempting the pre-trial chamber in your, personal capacity. Sa tingin niyo po ba, na-establish na ba ng prosecution at ng victims itong substantial grounds na requirement ng pre-trial chamber based po sa pinakita nila dito sa kanilang 2-day na presentation on Monday and Tuesday? Attorney F, and then we go to Attorney Taton.
Well, very systematic and methodical the way the prosecution presented its case. That's why they presented the facts as well as the evidence to prove yung murders that were committed.
Yes.
Then they link it to a common plan. So they have summarized the evidence on that. Then they link it to how systematic and widespread it was committed. In other words, every element has been presented, and they cited the evidence in support. Now, if you weigh the evidence, I think there is adequate evidence to support the charges that he committed 2 counts of murder and 1 count of attempted murder.
Now, if I were to judge, I can see substantial ground here. Although they have different approaches in presenting their case or causes here, we can see that in the prosecution side, they were able to present facts, and these facts can speak for itself as regards the pattern, the system, the widespread attack, the killings, the torture, etc. That would say that these are the elements, facts, but showing systematically how the elements of the crime are present in these facts. And that is one thing on the part of the prosecution. And on the part of the defense, they are there to destroy the facts, but the facts are quite strong enough to be destroyed by simple statements and only few legal grounds to present. For example, denial, non-insufficient or inadequacy of evidence. And I think by looking at this objectively, I think it's the prosecution for me today.
Yeah. And speaking of, facts and presentation, just for my last question, as echoed by Lian earlier, Attorney Nery Colmenares, one of the NUPL chairperson, NUPL members, former chairperson emeritus of the NUPL, mentioned that instead of, laying their own defense, what Kaufman did was actually to nitpick and to attack the evidence presented by the prosecution. Meron ba itong magiging effect dun sa kanya naging presentation overall sa assessment nyo? How do you see kung naka-apekto ba yun? Instead of laying yung kanyang arguments, ginawa niya, inisa-isa niya na lang. And in overall, tingin nyo ba sapat yung ginawa niya?
Well, on the merits kasi, it is the prosecution who has the burden to prove yung substantial ground. And you can also explain his tactics because he knows he doesn't need to present anything. He only has to find flaws, gaya sabi ni Attorney Nery, on the theory of the defense and the evidence of the prosecution.
Is the goal there is to destroy the pattern and the system, no? So I think what he did was best enough for the cause of the defense, because they cannot also go against the statements, the videos that were taken as part of the evidence of the prosecution. So I really think that his role there, he performed well as a defense lawyer there by presenting what he thinks is strong for his client and the supporters of his client. But in terms of evidence, in terms of the legal aspect of defense in a criminal procedure, especially in international criminal court, I think the prosecution failed. The defense failed to destroy the evidence presented by the prosecution.
Yeah. And lastly, any last message or thoughts, especially that Kaufman is down to his last hour of presentation. Tomorrow, he will have another 30 minutes. But basically, the 30 minutes is basically, ito na yung last message niya, ito na yung closing niya. But still have 1 hour to present yung kanilang, mag-submit ng kanilang merits or presentation dito sa kanilang merits. Ano pong in-expect nyo dun sa last 1 hour niya? Anong kailangan niya mapakita dun to really have a chance dito na hindi matuloy yung trial against Duterte?
Looking at the flow of his presentation, he wanted at the end to go back to how he started, about political, about the play of the NGOs, the media, and all that. That would paint Duterte as someone who really committed these killings and all that. And it was painted by the media after all. I think that's one thing that I expect him to do. Also, I think he will continue to present something about destroying the elements of the crime, especially as to the pattern, as to the concept of systematic attack. So, and I think, but it will really address not only the court, but the general Filipino supporters.
Well, Kaufman knows where his client stands. He already saw the evidence even before the confirmation hearing started. So what he's doing now is try to take advantage of this platform so that the narrative of the Duterte narrative will be played in public. So he's now performing to amplify the Duterte narrative, not so much to ensure that he will not go to trial. He knows that Duterte will go to trial based on the overwhelming evidence that he had been provided with. So what he's doing now is to just simply amplify the narrative, the Duterte narrative.
Yeah. Thank you so much, Attorney Efraim Cortez, Attorney Rodel Taton. That's Human Rights Lawyer and National Union of People's Lawyers President Efraim Cortez, and San Sebastian College Recoletos Graduate School of Law Dean Rodel Taton. Thank you so much, attorneys. Attorney Kaufman earlier mentioned the DAS Project, which documented cases of vigilante killings. And speaking of DAS Project, Kaufman mentioned that supposed killings under Marcos continued, but according to the data provided by the DAS Project, there are actually 342 incidents from July 1, 2022 to June 20, 2023. And that's the first year of Marcos. If we're comparing that to Duterte, 700 po ang pinatay sa first 3 months pa lang ni Duterte. That's really incomparable. Apples and oranges. But definitely, as Attorney Rodel Taton pointed it out, we should not be talking about the killings under Marcos in this case because hindi siya relevant in this case. For the meantime, please watch this Rappler documentary from 2024 where we documented the lives and the people behind the Dahas Project. Please watch.
If you do drugs in my city, I will kill you.
Magkaedad sina Mario Navarro at Kian de los Santos. Pareho ring taga-Caloocan, pero hindi sila sabay tumanda. Pinatay ng mga pulis si Kian noong 2017 sa ilalim ng drug war ni dating Pangulong Rodrigo Duterte, habang si Marion ay nagpatuloy sa buhay at ngayon nagbibilang ng mga patay. Sa edad na 23 anyos, nagtrabaho bilang research associate si Marion sa Third World Study Center ng University of the Philippines, Diliman. Bahagi ng trabaho ni Marion ang DAS Project. Ito ang proyektong nakatutok sa pagbibilang ng mga pinatay sa drug war ni Duterte hanggang sa kasalukuyang administrasyon ni Pangulong Ferdinand Marcos Jr.
Nakatira ako sa Caloocan. And nung nandun kasi sa height ng patayan sa Caloocan. Parang regular na siya nangyayari dun sa barangay namin. Lalakad ka, sasabihin sa'yo ng kapitbahay mo, alam mo ba may namatay dito? Kaya ako naging interested dun sa mga drug-related killings. In a way, ay magkaroon ng output na makakastop na sana nun in the future.
Sa basement ng Palma Hall sa UP Diliman, matatagpuan ang opisina ng UP Third World Study Center. Sa kanlungan ng Lumang Gusali, masugid na nagtatrabaho ang grupong nakatutok sa DAS project.
Ito ay isang matandang institusyon na binuo ito noong 1977 ni Dodong Nimenso and Randy David. Basically, para maging isang in a way safe space para sa mga critical sa Marcos administration noon na they believe na makakapag-offer pa rin noong panahon na yon ng stronghold kung may collective na pagsasama yung mga faculty at researchers ng UP.
Mula sa pagiging safe space, malaki ngayon ang ginagampanan ng DAS project ng UP Third World Study Center. Ang drug war tally na bunga ng kanilang pananaliksik ay nagdodokumento sa patuloy na patayan sa ilalim ng drug war.
Yung ginawa namin nung magsimula kaming ilabas weekly, yung count na nakikita namin. So yun, parang may gap din kasi na ng time na yun, parang nakafocus yung mga tao sa pandemic. Actually, isa sa mga unang summary ng data na nakita namin ay tuloy-tuloy yung patayan sa gitna ng quarantine. So yun yung nilabas naming report kagad. And sinundan pa yun ng iba pa, yung mga pinapatay ng mga barangay officials. Marami yun. Nakita rin namin yung trend na maraming foreigners ang napapatay sa drug war. So nilabas din namin yun.
Kada linggo, inilalabas ng DAS Project sa mga social media pages nito ang lingguhang bilang ng mga pinatay sa drug war. Maituturing na drug-related kung ang biktima ay pinatay sa bayolenteng paraan at pasok kahit isa sa mga kriteria ng UP Third World Studies. Sa DAS Project na ipapakita ang kahalagahan ng local media na madalas gumagamit ng police reports at blotters para sa kanilang mga balita na may kinalaman sa drug operations. Ang mga researchers ng UP Third World Study Center hinahanap sa internet ang mga media reports na may kinalaman sa drug-related killings at isinasama sa kanilang database.
So yung current method namin ng pag-gather ng data, ito ay purely online search na open source investigation, meaning ang ginagamit namin ay mga free and publicly available information online.
So ako yung assigned dun sa pag-search sa Google, so meron kaming list of keywords na ginagamit, and then may tinatawag na Google Alerts, so i-input yung mga keywords na yon and kinascar mo basically yung mga searches na lalabas sa Google Alerts, and titignan mo dun alin yung mga pasok dun sa database na ginagawa namin per week.
So dito sa tweet deck, each columns po ay nagko-correspond sa isang news outlet, and nakaset na dito ngayon yung mga search terms na ginagamit namin. So ang ginagawa, pag lumabas na yung articles, ay isa-isa namin tignan yung mga tweets na may nabanggit na patayan, titignan namin yung article na yun at babasahin pa. Pag may nakita kaming balita na determine namin pasok sa aming inclusion criteria, kino-compile namin sila dito sa list na ito.
After nun, ilalagay mo dun sa database yung pangalan, or kung unreported man, lalagay mo unreported or unidentified yung subject. And then lalagay mo saan nangyari yon, and binibilang namin yon sa buong week. Tapos kapag na-identify na namin alin yung mga talagang kasamang balita dun sa database, gagawan ko na yun ng PubMat, papacheck sa kanila, and after nun, ayun, ipopost na namin siya.
Pero dahil nga mga patay ang binibilang at na-expose ang mga researchers sa mga bayolenteng balita, nakaaapekto rin ito sa kanilang pamumuhay.
Isang challenge nga yung mental toll na nandudulot nitong paggawa nitong trabaho araw-araw, no? One way na talagang nag-manifest itong tinatawag natin second-hand trauma ay minsan naglalakad lang ako sa daan, tapos may motor na sasalubong. Yung taong ba yan ay pagka malapit na sa akin ay magbubunutan ng baril at babarilin ako. May ganun paranoia, pero natuto naman ako paano ito basagin, no? Kasi yung vicarious trauma, totoo talaga siya na yung pagre-report niya sobrang gory minsan. So ang magagawa mo ay wag mo ipapersonalize yung ginagawa mo sa trabaho. Kasi pagbabad ka talaga sa manong klaseng balita, parang ito na naging realidad mo. So, isang paraan na ginagawang para basagin yun at ito naman yung common na advice sa maraming bagay ay to do other things na para i-distract yung mind mo away from it.
Nang maluklok sa pwesto si Marcos Jr., sinabi niyang magiging iba ang approach ng kanyang drug war. Ang administrasyon niya, sinasabing bloodless o mapayapa ang drug war. Dito pumapasok ang kahalagahan ng DAS project. Dahil sa drug war tally ng UP Third World Study Center, nakokontra ang sabi-sabing mapayapa ang drug war ni Marcos.
Ayon sa tala, 556 na ang napatay sa ilalim ng drug war ni Marcos Jr. Mula yan nang maluklok sa pwesto si Marcos Jr. hanggang Pebrero 23, 2024.
Sa totoo lang, mas marami ang pinatay sa unang taon ni Marcos Jr. kumpara sa huling taon ni Duterte sa pwesto. Mayroong 342 na pinatay sa unang taon ni Marcos Jr. kumpara sa 302 ni Duterte noong huling taon niya.
I think yung Marcos administration ay very conscious na una, huwag sila matawag kaagad na magnanakaw. And pangalawa, huwag sila matawag kaagad na mamamatay tao. Pero yung departure sa demeanor ay hindi nagngangahulugan ng departure sa policy. Lahat ng patakaran sa tukhang, nandiyan pa rin. Yung mga nagpatupad ng tukhang, nandiyan pa rin. Masasabi mo lang kung gaano kabangis yung estado, kung may papakita mo kung gaano siya kahandang pumatay.
Dahil sa patuloy na pagpapatunay ng DAS project na hindi natatapos ang patayan, nakatutulong ito sa paggamit ng hustisya. Sa paraan kasing ito, hindi malilimutan ng mga tao na may mga krimen pa ring naganap o nagaganap. Sa katunayan, nabanggit pa ng United Nations Office of the High Commissioner for Human Rights sa May 2023 report nito ang malaking papel ng DAS project sa paggamit ng hustisya. Ang Real Numbers PH ng gobyerno na nagpapublish noon ng tally, hindi na naglalabas ngayon ng mga numero ng napatay sa ilalim ng drug war. Pero kahit nag-iisa na lang sila, tuloy ang laban para sa team ni Joel.
Gaya sinabi ko, ito ay pressure talaga siya kasi sa point na ito, wala kang option but to continue. Nandyan yun. But at the same time, parang kumbaga sa gera, ikaw na lang yung tumatakbo, and it's a killing field. So, sa mind mo, sana wag akong matapilok o sana wag akong mabaril sa ulo. Yun yung mentalidad sa ngayon. Na, sabi nga namin, nag-usap kami ng isang araw, sabi namin, hindi pa tayo nakamiss na hindi mag-post or hindi pa, yung post namin, hindi pa nag-contain ng such an egregious error na kailangan namin i-take back and mag-issue ng apology or something.
Habang nagpapatuloy ang patayan, patuloy ring magbabantay ang UP Third World Studies.
Ayaw namin mangyari yun na 50 years from now, yung mga scholars na titingin sa panahon ni Duterte at sa panahon ni Bongbong Marcos, maguguyo ng kung sino mang propagandista or mga apo ng dalawang ito at sasabihin, anong drug-related killings? At the same time na gusto namin maging obsolete yung archive, gusto namin itong maging resilient, na maging permanent record talaga, na doon pwede mong matingnan yung pangalan ng napatay, saan siya napatay.
Kung ang mga historiador ay tagapagtala ng kasaysayan, ang team na nakatutok sa DAS Project ay nagtatala ng krimen ng patayan. Ngunit higit sa pagbibilang, ang DAS Project ay ang proyekto laban sa pagkalimot sa kanilang mga nawala dahil sa gyera kontra droga. Jairo Boliedo Rappler, Quezon City. Hindi na Pangulo si Rodrigo Duterte, ngunit mahal pa rin siya ng mga tao, lalo na ang mga kababayang Dabawenyo.
Hindi bababa sa 60,000 ang pumuno sa kahabaan ng Recto at Rojas Avenue sa Davao City noong March 28, 2025. Ika-80 taong kaarawan ni Duterte, ngunit ang may kaarawan wala sa Davao.
We're here live outside the Villamor Air Base in Pasay, where we can officially report that former President Rodrigo Duterte, the once strongman leader of the Philippines, has been arrested over alleged crimes against humanity.
Wala kang puso, General Torres! Wala kang puso! Walang Marcos! Walang Marcos! Walang pinalibig yung tatay mo! Wala kang utang na loob! Ilabas na yan! Ilabas na yan! Ilabas na yan!
Former President of the Philippines, Rodrigo Duterte, is on a plane on his way to The Hague.
Nakakulong sa The Hague, Netherlands dahil sa kaso niyang krimen laban sa sangkatauhan o crimes against humanity. Bunsod ito ng drug war niyang kumitil ng buhay ng halos 30,000 katao.
Stop drugs and crime, criminality in 3 to 6 months.
Operation na Plantohan.
Happy birthday to you. Happy birthday to you. Happy birthday to you.
Malakas ang sigaw ng mga Dabawenyo. Malakas ang panawagang pakawalan ang dati nilang alkalde. Malakas ang pagtuligsa kay Pangulong Ferdinand Marcos Jr. at ang mensaheng makapangyarihan pa rin ang mga Duterte.
Marcos! Panalo mo! Wala ka diyan! Wala sila! Piling Marcosan eh! Nagpaka-Marcos yun ka! Laos na manunta ka! Doon lang kasama ang Vice Presidente walang nakakadiyan!
Maraming sagot sa tanong kung bakit nasa kapangyarihan pa rin ang mga Duterte. Ngunit may mga partikular na rason kung paano nila naabot at napanatili ang Duterte brand of politics. Para sa mga eksperto, Duterte Magic ang isa sa mga dahilan kung bakit nasa kapangyarihan pa rin ang dinastiya. Tumutukoy ito sa naging brand of politics ni Duterte at ng kanyang mga anak. Makamasa, astig, macho. Bahagi ng tinatawag na Duterte Magic ang pag-alok ni Duterte ng plataforma niyang nakatutok sa peace and order.
Ang problema natin, siya po, druga, drug lords. Pag ako ang presidente, itong order ko, hanapin ninyo sila. Patayin ninyo, period.
So when Duterte entered into the political scene in Davao in 1988, medyo Davao was in ruins. It's considered as a killing field during that time. Different forces on the right.
You're watching Rappler's special coverage of the pre-trial hearings of former President Rodrigo Duterte. Now we have live at this stage of our panel, Lian Buan, our senior investigative reporter, live from The Hague with human rights lawyer and chairperson emeritus of the National Union of People's Lawyers, Attorney Nery Colmenares. Lian?
Yes, Attorney, kanina we caught up during lunch nung nag-break. You were saying that, I asked you kung ano yung sinabi ni Kaufman that concerns you, that bothers you, and you said nothing much just yet. Can you explain what you said to me?
Yes, well, actually, we've sort of predicted before that President Duterte, once this goes to trial, won't have any evidence that will prove that he has nothing to do with the drug war. I don't think he has that evidence now. That's why they're trying to delay the trial, the confirmation of charges, and so on. And that was proven actually this morning when they didn't present any evidence to absolve him, but they merely attacked the prosecution's evidence. Was it strong? I don't think so. He needs to convince the court a lot of things. First, for example, whole population. There was no attack on the whole population. It's merely a targeted number of drug addicts and so on. Which for me, I don't think the court will say, "Oh, he's absolved. Then he only killed 7, 8,000, 10,000." Is that the whole population? I don't think there's a requirement of an attack to the whole population, but merely an attack against civilian population. Second argument, there was no command. There was no criminal plan. And the reason for that is he said there was no proof that the prosecution submitted to show that these people, the 8 perpetrators and President Duterte, met and agreed on a common plan. I don't think there's any evidentiary requirement that they should meet together to prove it. No, President Duterte, of course, devised the common plan. He ordered it, but he just needs to talk to Bato and Aguirre and say, look, we do this, right? Okay, yes, sir, they agreed. Then you talk to Albayalde and then La Peña and you say, we do this. You don't have to prove that they met. So I think medyo mahina yan if he's trying to convince the court that there was no common plan. I think he will lose there because I don't think the court will say, therefore it was a random killing. There's thousands of policemen began to want to kill thousands of drug addicts without any orders. They have an emotional problem this morning and they just killed somebody. No, I think the court will say, no. It was so systematic. It was a pattern. The public statements, the public orders, and then the encouragement of the killings, and then the execution, and then the cover-up, all this shows a pattern rather than a randomly executed killings without any criminal plan.
Let's talk about yung pinopoint out ni Nick Kaufman kanina na in the same speech that he apparently incriminates himself when he says to kill, he also exonerates himself when he says, well, you follow human rights, only act in self-defense, and then he would later go, the same document that you say exonerate because it uses the word neutralize is also exonerating dahil merong human rights in the next page, it will be corrected in the next year. Yes. What do you think of that?
Well, he did attack the prosecution's assertion that when President Duterte talks, there's a dual personality. The first is Duterte the strong man. Kill, I'm ordering you. And then later on in his speech, he will say something like, human rights. That's the lawyer, President Duterte, talking just to make sure that there's no clear accountability and can be used by, like this case in the ICC. So will he be able to convince the court that the fact that President Duterte mentioned human rights, therefore is absolved of the crime? I don't think so. Have they listened to the speeches of Duterte? It's 1 hour, 2 hours. And in 90% of the speech, he's going to say, kill, pardon, I'll pardon you, I'll fund you, I'll reward you. And then at the end of his speech, he mentions a sentence or two and say, respect human rights, and he's absolved. I don't think the ICC...
Ano bang legal standard when you say kill and then you say the next sentence, don't kill? What's the legal standard?
Yes, I would tend to agree with the prosecution. He's just trying to make sure that the criminal... This is a lawyer, right? But I don't think the court will be convinced that after all the long harangue, the speech itself, and then you just mention something, you're on the clear. I don't think so. For me, it's very hard to convince the court that there was no order merely because he inserted in some speeches, he didn't say human rights in all speeches. In some speeches, he inserted the word human rights or self-defense, and that clears up everything. So, for me, that's still a weak argument, but of course, it's up for the court to decide.
What is your response to Kaufman saying that, citing Dahas data, that killings continue to happen under President Marcos? Why is nobody, he says, why is nobody investigating the killings under Marcos?
That's the political side of that. That's not a legal argument for me. The fact that he said, well, there are still extrajudicial killings at the time of Marcos, and why aren't you condemning it? Well, he hasn't probably been long in the Philippines, if he ever visited the Philippines, but we have been condemning President Marcos' human rights violations. We've always said that extrajudicial killings is a systemic pattern in the Philippines. Not only Duterte, Marcos, Aquino, Arroyo, all these EJKs continue to happen. Except that President Duterte took EJK to a maximum high in the thousands. So for us, it doesn't prove anything. The fact that somebody else did it absolves me of this crime. Parang ginawa niya rin eh. But kami? I mean, that's not legal. And secondly, I'd like to add, it's not really true that parang itong masakit sa biktima eh. He painted them as parang you're pro-Marcos kasi you just filed this for political motivation. That really hurts. Why? We filed the case in 2018. For him to allege that, Marcos asked you to file it, we didn't even know Marcos was going to become president. Even President Marcos doesn't probably know that somebody will file a case against Duterte in the ICC and that they will break up. So to reduce the victims into, binayaran lang kayo o Marcos supporters kayo, bakit niyo kinokondem? Kahapon, nasa sentrum kami. We condemn Marcos continuing corruption and human rights violations. He should read better the victims here because that was a search for justice. You cannot reduce it to merely because we are favoring Marcos over Duterte. That's not the case. We don't favor, wala kami pakialam kay Duterte ka o Marcos ka. If you committed human rights violation, we will condemn you.
Kaufman was comparing the Duterte case to the El Hishri case, and one thing he said, he made a pass again at the ICC na dalawa lang kasi yung kaso nyo kaya ginagamit nyo talaga yung Pilipinas at si Duterte para pagmukaing meron kayong ginagawa, para busy kayo. What do you think whenever someone says that na parang the ICC is just using the Philippines to prove its survival?
Well, for me, that's another political statement. Yeah, that has no legal bearing. You attack the court, you attack the prosecution, not the evidence, but now the sort of the integrity. I mean, that's. But it's up for the prosecution and the court to say something about it. But for us, it doesn't go into the issue. The issue here is this: libo-libo ang namatay. President Duterte, ginawa mo ba yan o hindi? Kahit na sabihin mo, sige, ganito, may bias kayo sa nga Pilipinas ang birahin nyo, it doesn't matter. The fact is, thousands were killed. And you ordered it. So, what do you say? At yun ang hindi sinasagot ni Kaufman at ni President Duterte for a long period of time.
Jairo, that was Attorney Colmenares. If you have a question for him, I will relay.
Yeah, just a reaction, Attorney Colmenares, Jairo. Attorney, just last one question. Ano reaction mo doon sa sinabi ng ni Kaufman sa kanyang presentation na wala daw judicial records kasi dito yung sa neutralization, basically using that pitfall of our local justice system to, defend Duterte sa ICC, Attorney?
What's your reaction to Kaufman saying that wala naman daw judicial record yung neutralization?
Yeah, well, he wants to convince the court that the word neutralize doesn't mean kill. That's an intelligence term. That's a military term. And para sa amin, pag sinabi ng police, arestuhin mo yan o neutralize mo yan, alam ng police na iba ang ibig sabihin ng neutralization. But in any case, there are two proofs of the policy. A policy is an element of crime against humanity. The prosecution said the policy requirement is fulfilled by one, the public orders of President Duterte to kill. The second is the memorandum circulars. So the kill, of course, they didn't say neutralize. He said kill. So that's already a strong one. The second is the word neutralize was used in the official document. But I'm saying, of course, the police will not say in that memorandum circular, neutralize means to patayin mo na walang kalaban-laban. Of course, they have to mention something. It's a legal document eh. Parang ang sinasabi parang halimbawa, mga kongresista, sabihin nila, we swore an oath to follow the law, execute the law. nakalagay sa batas, bawal magnakaw eh. So, hindi kami pwedeng magnakaw kasi nag-oath kami sa legal document. Hindi alam ni Mr. Kaufman na sa Pilipinas, there are laws and there are constitutional provisions. But it's not followed. It's violated by so many people. And to rely on an official document to say, well, the document said neutralize, it doesn't mean you were ordered to kill. I don't think he can convince the court with that. But in any case, whatever the debate on neutralization is, the proof that President Duterte has a policy and ordered the killing is already clear in his public pronouncements since day one and even until now. No? So for me, I don't think the court will be convinced merely because of there's a debate on the word neutralize. So President Duterte didn't really order it. Therefore, for me, unbelievable. Because if that were the case, then why were there thousands of killings? Why? Again, we go back to the random killing. Because certain policemen, rogue policemen, don't want to follow the law. They interpreted neutralize as killing, so they killed them. I don't think the court will be convinced.
Right. Thank you. Kailangan na rin natin bumalik both sa gallery, Attorney Nery Colmenares. Thank you. That was Attorney Nery Colmenares, Jairo.
Yeah. Thank you so much, Lian Buan, our senior investigative reporter, live from The Hague. Kasama niya kanina lang si Attorney Nery Colmenares, human rights lawyer at dating chairperson ng National Union of People's Lawyers. Thank you, Lian and Attorney Nery. Speaking of neutralization, former Commission on Human Rights Commissioner Caris Gomez-Dumpit has provided us an insight about neutralization. May binigay siya sa ating short input. Sabi niya, according to her observation, Kaufman refers to a 2021 PNP manual in referring to the term neutralization or to neutralize. However, the period being examined is from 2013 to 2016 and 2016 to 2017. The 2013 edition of the PNP Manual of Operations should have been its basis. In that manual, a quick look mentions neutralization, neutralize about 5 to 6 times. And aside from that, according to former Commissioner Gomez-Dumpit, if you notice, neutralize appears on the text in tandem with apprehension, prevent, escape, capture. In other words, according to former Commissioner Karen Gomez-Dumpit of the Commission on Human Rights, neutralize is scaled as far as our local records and documents are concerned. Thank you so much, former Commissioner Gomez-Dumpit, for that insights. For the meantime, even if after Duterte has been arrested and detained at the International Criminal Court, he remains popular in Davao City. We have this documentary for you. Please watch.
Birthday to you. Happy birthday to you. Happy birthday to you.
Malakas ang sigaw ng mga Dabawenyo. Malakas ang panawagang pakawalan ang datinang alkalde. Malakas ang pagtuligsa kay Pangulong Ferdinand Marcos Jr. at ang mensaheng makapangyarihan pa rin ang mga Duterte.
Marcos! Panalo mo! Wala katiyak! Wala sila! Pinag-Marcosan eh! Nagpaka-Marcos yung ka! Laos na manunta ka! Dopanan na kasama ang Vice Presidente mo lang nakakatiyak!
Maraming sagot sa tanong kung bakit nasa kapangyarihan pa rin ang mga Duterte. Ngunit may mga partikular na rason kung paano nila naabot at napanatili ang Duterte brand of politics. Para sa mga eksperto, Duterte Magic ang isa sa mga dahilan kung bakit nasa kapangyarihan pa rin ang dinastiya. Tumutukoy ito sa naging brand of politics ni Duterte at ng kanyang mga anak. Makamasa, astig, macho. Bahagi ng tinatawag na Duterte Magic ang pag-alok ni Duterte ng plataforma niyang nakatutok sa peace and order.
Ang problema natin, siya po, drug lords. Pag ako ang presidente, itong order ko, hanapin ninyo sila. Patayin ninyo, period.
when Duterte entered into the political scene in Davao in 1988. Medyo Davao was in ruins. It's considered as a killing field during that time. Different forces. On the right, you have the military. On the left, you have the communist insurgents, and then you have the vigilante groups. Then aside from that, you also have the Muslim insurgents. So medyo magulo talaga yung Davao. And admittedly, sinasabi niya na peace and order lang talaga yung expertise ko. So ako na yung bahala sa peace and order, kayo na bahala sa the rest.
Ito rin ang kwento ni Malu Abella Lopez, dating aktivista at miyembro ngayon ng kontra-martial law at kontra-diktadurang grupong Konsensya Davao.
During the latter half of 1980s, the underground movement was really strong. And in Davao, I think they were already very near sa urban areas. Their presence was already felt, and a lot of abusive military and policemen were targeted by the NPA. At the time when Duterte became mayor, yun na-stop niya talaga yun.
Bilang alkalde, ipinagpatuloy ni Duterte ang imahe niyang astig. Nagkaroon ng bansag ang Davao City na isa sa mga pinakamapayapa sa Pilipinas. Nakilala rin ang syudad dahil sa mga progresibong mga ordinansya tulad ng pagbabawal sa paputok at paninagarilyo sa mga lugar pampubliko. Bawal din ang lumagpas sa 30 km/h na speed limit. Kay Duterte mismo galing. Sa Davao raw, walang mas mataas kaysa sa batas.
Ako naman basi sa Davao doon. Ano bang batas? O di sundin mo yung batas.
Naging ticket ni Duterte ang kanyang mahika patungo sa Malacanang. Naging point of pride din na unang pangulo siya mula sa Mindanao.
Ako ay tatakbo ng presidente at ayusin ko ang Mindanao.
Naniwala ang mga taong maaaring makapagpabago ng pamahalaan ang anti-crime platform ni Duterte. At nagtapos sa korupsyon.
I will go after for the corrupt lahat. Somebody has to answer for all of these things that's happening to the country. Kayong nasa droga, putang ina, papatayin ko talaga kayo. Tingnan ninyo. Kaya wala akong pasensya dyan. Wala akong middle ground dyan. Either you kill me or I will kill you, idiots.
Pero sa likod ng mga programa ni Duterte, ang katotohanang may mga extrajudicial killings sa ilalim ng kanyang pamumuno.
Di paglaban! Itigil ang pamamasdan! Itigil ang pamamasdan!
Kinumpirma ng mismong mga pulis na malapit kay Duterte na meron siyang Davao Death Squad na umano'y pumatay sa mga hinihinalang drug suspects at kriminal. Kinumpirma ng mga self-confessed PDS members na sina Edgar Matobato at Arturo Las Cañas ang mga di umanong kill orders ni Duterte.
Totoo naman na sinabi ni Edgar Matobato, mga pagpatay na utos direkta ni Mayor.
At mula sa Davao City, ipinatupad ni Duterte bilang presidente ang kanyang anti-drug template sa buong bansa na nakilala bilang drug war.
May operation of Plantokang.
Sabi ko sa pulis, do your work, arrest them, overcome the resistance, and if there is violence, kill them. Pagka lumaban, basta alam nila, kill, 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 kill.
He requested that I will locate a PNP officer or operative, indicating that he needed someone capable of implementing the war on drugs on a national level, replicating the Davao model.
Hitler massacred 3 million Jews. Now, there is 3 million
There's a 3 million drug addict per hour. I'd be happy to slaughter them.
Pero bakit buo pa rin ang suporta kay Duterte? Lalo na ng mga Dabawenyo sa kabila ng lahat.
Naiintindihan ng mga tao na ginagawa ito for peace and order, no? Kasi rather than you will become victims, no? Yung mga addict na lang yung magiging biktima. So rather than us, sila na lang.
I think Duterte was really trying to create war. War, let people believe that there's something war happening. And that antagonists are those criminals. And there's the idea of it's not anymore negotiable. Because for us to win the war on drugs, we need to kill people. No, parang there's a monopolization of who have the right to kill. And I think Duterte was able to parang inculcate that in the value systems of people in terms of who gets to decide who to kill.
Sa mata ng taga Davao, simpleng tao si Duterte at may history sila o may pinagdaanan kasama ang dating mayor.
Kamong ang akong programa para yun sa gamay.
Hindi nila kasi ma-relate yung kanilang good personal experience with Duterte sa bigger picture. Like for example, believe ako kay Duterte yung no smoking niya. Kasi it really saved lives. So ilang tao kaya ang hindi nagkaroon ng lung cancer because of that no smoking?
Isa rin ito sa mga tinitingnang dahilan kung bakit may ningas pa rin ang Duterte Magic.
We have this para sa masa, gikan sa masa.
Maayong buntag mga kapamilya. Welcome sa atong programang Gikan sa Masa para sa Masa. Maayong buntag kanimo Mayor.
May buntag kanimo Geraldine, may buntag kaninyong tanan.
So that's a television, just one of the many parang visibility of Duterte's in the city to really provide that sense of closeness, no, to the people, and that was consistent because the way he talks, the way the semantics of it, na parang all of that were very relatable to the people. So I don't know if you also remember that there's also parang clips of Tatay Digong, roaming around in the city through the taxi. So parang in a way, parang he is also building himself not as a politician but as someone tatay, no? And even the word tatay, parang there's a sense of closeness to the person. It's not just someone random stranger politician, but this is our tatay, and that imaginary of social kinship, na parang you are someone protected, you are someone nurtured, you're someone loved by this tatay. It gives the idea na parang Davao is stable because of tatay, and that kinship na ingrained into parang Davaoenos.
Tulad ng ibang politiko, tanyag pa rin ang Duterte brand of politics dahil sa kanilang dinastiya. Kontra sa sinasabi niyang siya'y simpleng tao, mula sa pamilya ng mga politiko si Duterte. Anak siya ng dating Davao Governor Vicente Duterte na nagsilbi noong dekada 50 at ng kilalang anti-Marcos civic leader na si Soledad Duterte. Bago pumasok sa politika, naging piskal muna si Duterte sa tulong ng yumaong Davao City Mayor na si Elias Lopez. Malapit noon sa mga Lopez ang pamilya ni Duterte.
Digong graduated from college and became a lawyer. So, Nanay Suling approached my father, asked help that he be appointed as a fiscal here in Davao City. My father worked for it in with the Minister of Justice at that time, Abad Santos, and Abad Santos provided a solution, creating a new position for Duterte, only for Duterte, and let President Marcos at that time sign that executive order. So when my father returned home, he told Nanay Suling and Digong, here's your appointment papers. You can start tomorrow. So he became a fiscal.
Magkakawit kamay at bisig tungo sa
Ang pagbagsak ng diktadurang Marcos ang nagbukas ng pinto sa karerang politikal ni Duterte.
Then during the People Power Revolution, when Nanay Suling was very active in the anti-Marcos dictatorship, was recognized by Cory as a leader of the anti-Marcos, and I think they said that Cory offered her the position of vice mayor. Pero si Digong was not anti-Marcos. Only Nanay Suling. So maybe Nanay Suling felt daw that she was already old and advised Cory to appoint her son Rodrigo as vice mayor.
1988 nang manalo bilang alkalde si Duterte at tinalo ang appointed mayor ni Cory Aquino na si Zafiro Respicio. Sa 1988 race ni Duterte, muli siyang tinulungan ni dating alkalde Lopez.
So my father said, "Oh Rudy, you file your candidacy tomorrow." And Rudy Duterte said, "Me? Sir? Ako? Yes." Oh, sabi ng father ko, "File ka bukas for mayor. Ikaw ang kandidato for mayor," sabi ng father. Ngayon, nagulat si Duterte, sabi niya, parang shock siya, gano'n. O, di sinabi ng father, kasi hindi naman nasa isip niya yun eh. Then my father said, abogado ka, di ba? Sabi niya, abogado ka, marunong ka mag-file, di ba? O mag-file ka bukas. O nag-file si Duterte. And the rest is history. We campaigned for Duterte. My father brought karga-karga niya, 1st district, 2nd district, 3rd district, the entire Davao City.
So for the 3 terms, from 1988 to 1998, kaya people really enjoyed how Rodrigo Duterte managed Davao City. So doon po nagsimula
Mula 2001 hanggang 2010, nagsilbi pa ring alkalde ng Davao City si Duterte. Pero 2007, nang masemento ng mga Duterte ang kanilang dinastiya sa Davao sa pagkaluklok ni ngayon Vice Presidente Sara Duterte bilang vice-alkalde. Ito rin ang naging mitya ng paghihiwalay ng mga Lopez at Duterte.
Duterte chose Sara Duterte. Bagong graduate, not known here in Davao, etc. Kasi Digong sabihin sa akin, sabi niya, kung tapang lang Roy, sabi niya, tapang lang Roy, mas matapang sa akin kaysa mas matapang yan si Sara kaysa sa akin. If you're the mayor and then the vice mayor is your daughter, who is the vice mayor is the daughter who is the presiding officer of the local legislative council, wala nang checks and balances yan. So they can do what they want with the money of the city. So diyan papasok siyempre yung abuses na lahat, corruption and everything. But so yun, I told Duterte, sabi ko, Digong, sa ganyan, hindi na ako sasama sa iyo. Sabi ko sa kanya.
Sa loob ng 30 taon, mula 1988 hanggang sa kasalukuyan, Duterte lang ang umupong alkalde sa Davao City. Liban noong 1998 hanggang 2001 kung saan nagsilbi si Benjamin de Guzman na mayor. Mula kay Duterte, naipasa niya ang pagkaalkalde sa anak na si Sara. Si Sebastian naman ang tumakbo at nanalo noong 2022 dahil kumandidato sa pagka-vice-presidente si Sara. Si Paulo Opolong nagsisilbi ring 1st District Representative ng Davao City mula 2019. Ang asawa ni Pulong na si January Navarez Duterte, chairperson ng Barangay Catalunan Grande. Siya ang presidente ng mga liga ng barangay kaya may mandato rin siyang para ring konsehal. 2 anak din ni Pulong ang nasa politika. Si Barangay Buhangin Proper Chairperson Omar na tumatakbo sa pagkakongresista sa Davao City 2nd District at si Rodrigo II na tumatakbo sa pagkakonsehal. At ngayong 2025, muling tumatakbo sa pagkaalkalde si Duterte habang running mate niya ang anak na si Sebastian. Hindi bababa sa 7 miyembro ng Duterte Dynasty ang nasa mundo ng politika. Kahit iilan, may mga tao at institusyon pa rin sa Davao City na tumitindig, mapa sa politika man o laban sa mga questionableng polisiya. Isa ang development worker na si Mags Maglana sa mga umaharap sa mga Duterte. Nilabanan niya sa pagkakongresista ng 1st District si Pulong noong 2022 at muli niyang nilalabanan ang representante sa parehong posisyon para sa 2025.
In 2037, centenary or centennial ng Davao. Gusto ba natin na ang mukha ng Davao in 12 years time bilang isang daang taon na syudad ay ganito pa rin? Baha, traffic, mataas na presyo ng bilihin, problema sa trabaho, demolisyon, problema sa pabahay.
Aminado si Mags na hindi magiging madali ang laban. lalo na't matagal na sa posisyon ang mga Duterte.
The focus of the local government shall be the welfare of the Davaoenyo.
Alam mo, sasabihin ko, hindi madali. Pero sasabihin ko rin, hindi imposible. Kasi kung babalikan mo ang kasaysayan ng Davao, if you take a look as far back as 1956, ang kasaysayan naman ng Davao, so totoo lang, medyo yung tinatawag na thin dynasties, no? Sunod-sunod, no? Pero nagbabago over time. So it's not as if things have not changed in Davao. Maybe not as fast, but things do change. Kailang there is something to be said about dynasties.
Bilang oposisyon sa baluarte ng mga Duterte, nakararanas si Mags at ang kanyang mga taga-suporta ng ilang forma ng pangharas. Pero para kay Mags, naiintindihan niyang dapat ipagpatuloy ang laban.
Sa tingin ko, obligasyon nating magsalita. At ito ang sinasabi ko sa aking mga kaibigan when I encourage them to speak out. You know, one of the reasons why talagang nag-consolidate at nag-take hold ng mga Dutertes ay because of the narratives of how former President Duterte turned the situation around when he became mayor, no? Pero ang naging naratibo kasi is parang it was just him and his will, no? And that turned us around and made us peaceful and stamped out criminality and all that. Hinayaan namin yung naratibo na yan eh.
May kabataan din sa Davao City na bukas ang mata sa realidad. Pero kahit pa mahirap ang laban, naniniwala si Catherine sa kapangyarihan ng pamamahayag.
Talagang mahalaga po kasi at sa media landscape natin ngayon na talamak masyado yung fake news, yung mga misinformation, disinformation. It's time na ma-view nila na ang journalism is a form of activism din na through writing, you can really amplify and kanang expose kung ano talaga yung realidad na nangyayari sa komunidad mo.
Kahit anong tayog ng dinastiyang Duterte, mayroon at mayroon pa ring mga bagay na susubok sa kanilang tikas. Masikip ang 2025 race para sa mga Duterte dahil mabibigat din ang mga kumakalaban sa kanila.
Yung unang power play dyan is that yung mga major political families no, na sumuporta sa kanila in the previous years, no, in the several decades, pinalaban na nila.
Kinakalaban ni Duterte sa pagkaalkalde ang dating cabinet secretary at spokesperson na si Carlo Nograles. Sa pagka-vice mayor naman, kalaban ni Sebastian ang dating vice mayor na si Bernie Alag. Bukod kay Maglana, nilalabanan din ni Pulong sa 1st District si PBA Representatives Mix Nograles Almario. Mabigat din ang kaharap ni Omar sa 2nd District dahil mula si Javi Garcia Campos sa dinastiyang Garcia na hawak ang nasabing distrito. Kaya mahalaga ang 2025 para sa pamilya Duterte dahil susubukin ito ang posisyon nila sa Davao City. Bukod sa banta ng eleksyon, nariyan din ang pagka-aresto kay Duterte sa International Criminal Court dahil sa kanyang drug war.
I am Rodrigo Duterte.
Mayroong ding nakapintong impeachment trial si Sara at kung siya'y makoconvict, hindi na siya maaaring humawak ng kahit anong posisyon sa gobyerno.
There is a motion to direct the Secretary General to immediately endorse to the Senate the impeachment complaint. Is there any objection? The chair hears none. The motion is approved. The Secretary General is so directed. The session is suspended.
Para kasi sa mga eksperto, ang kapangyarihan at impluwensya ng dinastiyang Duterte ay nakaangkla kay Duterte at mayroong sarili ring impluwensya si Sara.
I think with Sara, it was easier to parang transfer the quote-unquote power because Sara was also into that patriarchal strong force, strong man agenda.
Dala ko ang tibay ng puso ng Pilipino na gawin ng lahat sa aking trabaho para tayo merong mapayapang pamumuhay dito sa ating bansa.
Ayon sa mga eksperto, hindi kasing popular ni Duterte at Sara ang ibang kapamilya.
Dalawang lalaki kasi medyo hindi nila talaga nakuha yung charisma, the way that the father would speak. They tried to copy.
Ako instrument, ako sulugoon lang ko ninyo. Maunin tinuod diri. Hindi ta mo mabiyaan.
Pero hindi, malayo talaga, despite his age, his health, and of course, itong kinakaharap niya na ICC na kaso. Pero yun pa rin, nagugulat yung iba na bakit kailangan niya pang tumakbo. So parang, nakikita nila, possible ba na matatalo ng Nograles, kung sino man tatakbo for mayor, kung hindi si President Digong yung tatakbo mismo.
May the Lord God bless you, Tatay Digong!
Ngunit para sa mga eksperto, dito ngayon pumapasok ang paggamit ng ICC para sa politikal na interes ng mga Duterte.
Politically speaking, parang it's helping them.
Sinabi niya na bantayan natin ang ating boto dahil ang mga tao na desperado ay kung ano-anong pandaraya ang naiisip.
Because again, when the Duterte's campaign for this election, the brand is 4Ds. So not just Duterte, Rodrigo, it even solidified the vote, because they're using that concept of Mindanao vote, and the regionalism, and even now the nationalism, na parang it's us against you.
Sa kabila ng mga agam-agam, maliwanag pa rin na makapangyarihan pa rin ang mga Duterte at buhay pa rin ang Duterte Magic, mapa Davao o sa buong bansa. Hindi sa tadhana kundi nasa botante nakasalalay ang kapalaran ng Duterte Dynasty. Tao ang nagluklok sa kanila, kaya tao rin ang hatol kung mananatili ba ang apelido nila sa larangan ng politika. Jairo Bulyedo, Rappler, Davao City.
Pilipinas Duterte pa rin! Pilipinas Duterte pa rin! Mabuhay ang Team Duterte!
Special coverage of Duterte's pre-trial hearings at the International Criminal Court. I am Jairo Bulyedo. Today is the third day, and we are hearing from Duterte's counsel, Nicholas Kaufman. So again, this is the third day of the 4-day hearings. So far this day, as we've been mentioning, this last hours, this is dedicated for the defense. Ibig sabihin po nito, after magpresenta ng merits nitong prosecution at ng mga biktima, tsansa naman po ng defense team na pasinungalingan o pabaluanan po yung mga pinakitang ebidensya, pinapayawan o pinatikim na ebidensya nitong mga prosecution o ng prosecution po. So far, in-establish ng prosecution na yung elements o yung mga bagay po na nagko-constitute o gumagawa ng crimes against humanity ay nagawa daw ni Duterte. Base po dun sa presentation ng prosecution na nakaraan, si Duterte daw po ay criminally liable, individually criminally liable po dito sa kaso ng crimes against humanity sa 3 counts as indirect co-perpetrator. So ngayon po, itong si Nicholas Kaufman bilang abogado po ni Duterte at ng defense, siya po ay inuna niyang ipabulaanan yung mga speeches daw ni Pangulong Rodrigo Duterte. Ang sabi niya ay yung mahirap daw patunayan yung criminal intent o mahirap daw patunayan na may criminal intention daw itong si Duterte solely based on speech. Sabi niya rin ay sinasabi naman daw ni Duterte doon sa kanyang supposed kill orders na itong mga papatayin nila na mga biktima o na mga alleged suspect ay yung mga nanlaban lang daw. Basically, just echoing the justification by the Duterte administration and justification made by Duterte himself. But it's important to note that according to Attorney Ted on the other day, sabi niya, in the criminal intent, it's also important to establish kung nagjo-joke lang ba talaga o hindi, kung binawi ba yung statement na yun o hindi. And in this case, we can deduce that Duterte did not actually take back all of those statements in the last years. In fact, in 2024, during the Senate Blue Ribbon Committee hearing, in 2024, when he was invited by the upper chamber, Duterte himself admitted to these killings. He actually said that he actually encouraged his policemen, his cops, to induce the victims to fight back so that they can justify the killings. There was no remorse in that statement, and in fact, the very same Senate Blue Ribbon Committee hearing that we're talking about has been used by the prosecution in their presentation on the merits. Aside from that, Duterte, or Kaufman rather, also said that these statements by Duterte are just, they're just hyperbole. The president or the former president was just exaggerating, and this not actually, or this speech does not actually show crafty design or meticulous design or organized crime. In other words, in crimes like this, as we've said earlier in the panel, it's important to prove that the elements of crime has been committed. Meron po mga elements, may mga requirement po sa isang krimen. At importante po na yung mga elemento na yon ay mapatunayan ng prosecution na ginawa o nagawa ni Duterte. At isa po sa mga elemento na yon ay tinatawag pong pagiging wide scale or organized po ng pagpatay para masabi daw na crimes against humanity, yung kinakaso po kay Duterte. Kaya yun po yung sinusubukan dito ni Kaufman, ipakita po na wala daw crafty design. And speaking of crafty design, importante rin po sa crimes against humanity yung tinatawag po na common plan. Kasi itong si Duterte, siya po ay akusado or siya po ay suspect dito sa crimes against humanity bilang indirect co-perpetrator. Iba po kasi ang proceeding sa ICC, indirect co-perpetrator siya dahil, katulad nga po in-explain ng maraming eksperto sa international law, indirect co-perpetrator ang tawag sa kanya dahil hindi naman siya talaga yung gumawa diretso nung krimen. Indirect co-perpetrator, in essence, siya yung nag-utos doon sa mga pumatay. In other words, possible, kailangan establish na guilty pa rin siya by establishing yung tinatawag na nexus o yung connection ni Duterte doon po sa mga nag-trigger talaga ng baril. Kailangan mapatunayan po ng prosecution na yung utos ni Duterte, may system ng pagpatay na ginawa ni Duterte at inutos ni Duterte para gawin yung mga pagpatay na yun nung nasa pinakababa ng pyramid. At yun po yung nakita nating figure na prinesenta ng prosecution the other day. At yun po yung gustong gawin dito ni Kaufman. Wala daw common plan, hindi daw totoo yung common plan ayon kay Kaufman. In fact, if we're talking about the common plan daw, ay itong common plan daw ay actually inaprobahan pa ng majority ng Filipino people by voting Duterte or by electing Duterte to the highest post in 2016. And aside from that, sabi din ni Kaufman, another thing na ginawa ni Kaufman is to justify the killings. He said that the Oplan Tokhang is actually lawful because if we're gonna go at the wording of the word Oplan Tokhang means knock and plead daw, making it a police legitimate operation. It's important to highlight and to point out that it's not really a question whether those operations are legal, whether those operations are legitimate, but rather what happened in those operations, how many people were killed. And that's the argument of the prosecution, that's the argument of the victims. Really, I mean, it's an order, it's a state order, utos yun ng Estado. Hindi naman question kung ginagawa ba ng police yung trabaho nila, pero according to the victims, according to the human rights organizations, what the police did was to kill the victims of this war on drugs. Aside from that, Kaufman also claimed that the DDS or the Davao Death Squad is completely fictional, and as far as the witnesses are concerned, the DDS or the Davao Death Squad is not completely fictional, at least according to the statement and affidavits of two witnesses, Edgardo Bato and Arturo Las Cañas. Now, nakikita na po natin na magsisimula na ang last part ng hearings today. Kaufman has 1 hour to present the last few parts of his presentation on the merits, and we're expecting Kaufman to now zero in the issue of jurisdiction. Ito po ang pinakamabigat nila na ebidensya or presentation as far as Duterte's case is concerned. Please watch.
An oral ruling regarding the redactions made to the transcript and direct broadcasting today. The Chamber notes that redactions were made to the transcript and to the direct broadcast of the hearing subsequent to an application by the prosecution and which was opposed by the defense. The application of the requested redactions apparently would be a problem and could lead to hearings being held in closed session. The Chamber wishes to recall an earlier ruling during which the Chamber stressed that it is up to the parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
Thank you, Madam President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of two citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show that the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? how has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example. Transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyse the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation or inducement with respect to any one of the 49 incidents. No documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b)? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalised statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish the prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top, via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55, the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyse it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts in common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pre-trial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hola of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hurler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54(3)(D) of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. They cooperate through me, since I don't hold a position. Redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the President, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defense firmly submits that the pre-trial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defense to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the the hoary old chestnut of conflicting statements emanating from two or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the sixth weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents in the three counts as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay, and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
Nakatutok pa rin po kayo sa special coverage ng Rappler para sa ikatlong araw ng pre-trial hearing ni former President Rodrigo Duterte sa International Criminal Court. Bago po maputol ang stream ng ICC, ay pinapakinggan po natin ang pagtatapos po ng statement at presentation ng merits o ng mga pahapyaw na ebidensya nitong lawyer ni Duterte na si Nicholas Kaufman. To recap lang po, so far ang mga na-mention niya, patuloy niya pa rin po ang kune-question ang mga ebidensya, ang mga facts, ang mga impormasyon po na provide ng prosecution dito laban kay Duterte. Particularly, isa doon sa mga in-establish ng prosecution dito kung paano ka-organize daw itong patayan under Duterte ay yung PRRD list. Minensyo yun ni Kaufman at ang sabi niya, dinownplay niya again yung killings. Ang sabi niya, wala naman daw certainty na kapag napunta ka sa PRRD list ay mamamatay ka. In fact, kung titingnan daw natin ang percentage nung mga taong na lista doon at sa mga taong napatay, nasa 5% lang naman daw. And that's how Kaufman basically downplayed this point of the prosecution. That is direct attack on the second count of the crimes against humanity case against Duterte. The second count refers to the killings of 14 high-value targets in the name of former President Rodrigo Duterte's drug war. But if we're gonna look at the prosecution's argument as far as that second count is concerned, the problem there is that masyadong arbitrary and the manner of the attacks are really organized. Ang sabi ng prosecution, the mere fact daw talaga na malagay ka doon ay halos sure na as far as the Espinosa or the Rolando Espinosa and the Parihunog's case are concerned. And apart from that, Duterte's lawyer also mentioned without directly mentioning their name, he also alluded to the witnesses of the prosecution, which are Arturo Las Cañas and Edgard Matobato. Basically, hindi niya pinangalanan because Kaufman is not allowed to disclose the names of these witnesses. Hindi siya kasama doon sa public redacted version of these documents. And now we're back at the chamber as Kaufman continues his speech. Please watch.
Does not permit charges to be confirmed on the basis of conjecture, on the basis of such a weak evidentiary basis. Now, since the prosecution made such a big deal out of incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in
Once again, hindi na po natin mabilang kung ilang beses naputol itong stream ng ICC. But once again, naputol po ang stream ng International Criminal Court. Kanina we asked our reporters on ground kung ano nangyayari kapag merong ganitong private hearing. Ang sabi ni Lian Buwan kanina, isa sa mga reporters na nagko-cover natin on ground, ang nangyayari daw doon ay nawawalan din daw sila ng audio doon sa kanilang pinaroroonan at nagkakaroon din daw ng curtain para hindi nila makita kung ano nangyayari. Kanina nakasama natin si Dean Rodel Tato ng San Jose College Recoletos Graduate School of Law. Sabi niya rin kanina off-cam na ganun daw talaga yung proseso sa ICC. Part daw yun ng briefing sa kanila ng mga nag-aral nitong international law para daw proteksyonan yung mga bagay, yung mga information na supposedly hindi pwedeng i-consume ng public. There's a reason kung bakit hindi public redacted version po yung mga documents ng ICC. Kung napapansin nyo po, napaka-transparent nitong ICC as far as documents are concerned. Pero may mga limitations po yun. Kaya yung mga available lang, yung mga information, mga pangalan, mga lugar, mga sequences na pwedeng i-provide nila, yun lang po yung nilalagay nila sa mga dokumento po na ina-upload nila sa kanilang website. At kanina sa hearing, bago po magsimula itong last part ng speech ni Kaufman, pinaalalahanan po siya ng presiding judge ng Pre-Trial Chamber na si Judge Yulia Motok na there's a reason kung bakit public redacted version lang allowed na i-mention at i-disclose during the trial. Going back to Kaufman's arguments earlier, as I was saying, he was trying to question the veracity, the authenticity, and the weight of the evidence and testimonies provided by the former and self-confessed Davao Death Squad members, Arturo Las Cañas and Edgar Matubato. These are self-confessed TDS members, and as far as available information is concerned, they are currently at The Hague or at the International Criminal Court as witnesses in this case. In particular, witness po si Las Cañas at si Matubato sa first count ng crimes against humanity cases laban kay Duterte, in particular yung killings concerned or under the Davao Death Squad. According to Kaufman, ay hindi credible witness itong dalawa dahil sila daw ay dating miyembro nitong isang criminal enterprise o alleged member ng criminal enterprise na naghahanap lang daw at nagpo-provide ng kanilang testimonya para ma-exonerate sila o mapawalang sala sila dito sa criminal enterprise. But we're gonna look at the wording of Attorney Kaufman. There's a bit of problem with that because he said earlier that the Davao Death Squad is fictional, but now he's saying that, or he's referring to these unnamed witnesses as former members of a criminal enterprise. Aside from that, he's also trying to, question the prosecution's evidence by saying na wala daw magpapakita ng ebidensya kung paano inutos ni Superman or in this case Duterte yung kanyang kill orders. Again, inuulit niya na wala daw information, wala daw ebidensya, wala daw facts na magkoconnect kay Duterte dito sa gunman. As I've explained earlier, it's important here because Duterte is being charged as an indirect co-perpetrator. It has been established that the killings are there. Duterte is not the gunman, obviously, but in this case, siya po ang sinasabi na nasa likod nitong mga pag-uutos na ito doon sa sistema, sa organized and widespread attack against a civilian population. And in this case, importante po at siya po ay liable, according to the prosecution, as an indirect co-perpetrator. Hindi man siya ang bumarel, hindi man siya ang bumunot ng gatilyo or bumaril po doon sa mga biktima, siya naman daw ang nasa likod nitong mga operasyon na to. At yun po yung dahilan kung bakit po siya liable pa rin as indirect co-perpetrator. May sala pa rin siya, allegedly, according to the prosecution, dahil siya ang nasa likod ng operasyon. Ngayon, itong si Kaufman, paulit-ulit siya na wala daw pong ebidensya na magtuturo kay Duterte na allegedly kasama po siya or makokonek po siya doon sa mga gunman na bumaril at pumatay po dito sa mga biktima. Bukod po doon, kanina na-mention po ulit ni Attorney Kaufman dito kay Attorney Kaufman itong pangalan ng administrasyon ni Pangulong Ferdinand Marcos Jr. In particular, inulit niya yung kanyang claims sa opening statement niya na allegedly meron daw isang tao na nag-ooperate in the name of Marcos administration na allegedly nagsusupply ng witnesses, nakipag-cooperate, nakipag-usap dito sa International Criminal Court. Ang sabi rin ni Kaufman ay may isang na-wiretap na official na nasabi at napatunayan nila at sinabi doon sa conversation na yon itong mga bagay na to na nagsusupply nga siya allegedly at nakipag-cooperate sa International Criminal Court. The problem there is that seems to be not a legal argument, but more of a political and a swipe against the Marcos administration. And again, as established by the experts that we've had here a while ago, Attorney Efraim Cortez and Attorney Rodel Taton, the problem here is that, Kaufman, pwede niyang i-bring up ulit ang pangalan ng Marcos administration, yung mga alleged crimes under the Marcos administration. But the problem is they're not legal arguments. They will not help in their defense, but rather nakikita nila ito ng mga eksperto natin bilang more of on the political side at doon sa side na magbe-benefit yung political ambitions, yung mga political against nitong Duterte administration, because these statements directly, they are directed toward doon sa mga supporters ng Duterte administration at ng pamilya Duterte. And then before po ito matapos ulit or mapause itong si Kaufman dito sa kanyang statement, inisa-isa niya yung alleged weaknesses nung mga points or yung mga arguments na hinighlight ng prosecution at ng victims in the last 2 days. Una, sinabi niya, may heavy reliance daw po doon sa mga testimonya na ibinigay nung mga supposed unnamed na witnesses na to, and is probably 100% referring to Las Cañas and Bato. According to Kaufman, he is claiming that these statements are not corroborated by external sources. Unfortunately, that's not entirely true in this case, because as far as the DDS killings are concerned, if we're talking about these killings, marami na pong documentation, external and independent documentation that basically narrates and na-cover po itong killings na to. We are talking about the Human Rights Watch report that mentioned the killings in Davao City. In particular, we can talk about the Clarita Aliyah case. Siya po ay isang nanay doon sa Davao City na mayroon po siyang 4 or 3 anak na pinatay sa Davao City. Well documented po ng Human Rights Watch yung kanyang kaso. Aside from this Human Rights Watch report, meron din pong independent investigation ang Commission on Human Rights under former CHR Commissioner and now Congresswoman Laila De Lima. And according to De Lima herself, that is one of the reasons why Duterte attacked her. Naging politically motivated yung attack sa kanya dahil isa po siya sa mga officials under CHR ang nag-imbestiga as early as early 2000s or 2010s dito po sa kaso ng Davao Death Squad. So hindi po totoo na ang available information lang dito sa killings na to, sa Davao killings na to, ay hindi po corroborated by external sources. As far as independent organizations are concerned, meron pong mga documentations with that. Ngayon, sinasabi rin po nitong si Kaufman na manipis daw po ang documentary evidence na pinrovide ng prosecution. Pero kung titingnan po natin yung pinrovide nila, as apart from highlighting the speeches of the former president, they were able to establish the links, how organized itong mga killings na ito by highlighting yung mga documentary evidence katulad po ng Memorandum number 16 series of 2016 ng Philippine National Police na pinirmahan po ni former PNP chief and now Senator Bato Dela Rosa na pinangalanan po ngayon na co-perpetrator dito sa kaso na to, among other po ng mga documentary evidence na pinrovide ng prosecution. Aside from that, kiniklaim din po nitong si Kaufman paulit-ulit before po maputol itong stream niya na meron daw pong repeated absence doon sa relationship between the gunman and Duterte o yung link po sa kanilang mga acts. Para sa kanya, hindi daw po napatunayan ng prosecution na yung mga sinasabi ni Duterte talaga ang sinunod ng mga gunman at yung mga words, mga utos ni Duterte ang nag-encourage sa mga gunman para gawin po yung mga binibintang o para gawin po yung mga krimen na pinag-uusapan po natin ngayon dito sa International Criminal Court Pre-Trial Chamber 1. As of this moment, it's 10:27 Philippine time. Supposedly, the hearings or the pre-trial hearings will end at 10:30 Philippine time. So far, meron pong 2 to 3 minutes na lang si Kaufman para sa kanyang speech. Intayin po natin, antabayanan po natin kung ano na po ang mangyayari in the next few minutes. For the meantime, mag-break muna po tayo ng panandalian.
prosecutors, the registry, the technical staff, and all those who have allowed this. Yes, Mr. Nichols?
To interrupt, Your Honors, just at the end of the day, but I wonder if we could go into private session for 1 minute before you leave the bench.
Oui, Mr. Nichols.
Yes, Mr. Nichols?
We are back in open session, Madam President.
Judge Motok, I was thanking the participants and parties, and then we had a few moments in private session, and now I would like to wish you a pleasant afternoon. We will see you all tomorrow, and once again I thank everyone, and this hearing is now adjourned. We will see one another tomorrow.
The hearing has just finished. That ends the defense's presentation for the pre-trial hearings. Let us watch this report by Rappler Senior Investigative Reporter Lian Buan.
You just heard Nicholas Kaufman close his submission on the merits today for day 3. Remarkable in his submissions where he was really going after the insider witnesses of the prosecution, who we now can say are the Davao Death Squad insider witnesses. Parang sinasabi niya na how can the prosecution essentially so much as give them immunity from prosecution if they are themselves confessing to carrying out murder. Sabi niya, the prosecution will claim that they have not given immunity to these ruthless murderers, to quote him. But Kaufman said, essentially yun na yung nangyari because sabi niya, I dare you, we will not see these witnesses on the dock in the International Criminal Court or at any dock anywhere else in the world because they have been rehoused on the cost of the state party. So that was what was very significant on his submission on the merits. He was saying that to give, it's morally repugnant to give self-confessed murderers the chance to be immune from any suit just to be able to pin down an alleged murderer. Sinabi niya nga na 2 of the most star witnesses were offered up on a silver platter by someone that I cannot name. This is very closely linked to what's happening back home, considering that we have just seen those affidavits circulating back home about an alleged operation to help ICC investigators, although the Office of the Prosecution of the ICC has sent us a statement yesterday that it conducts its investigations independently and is funded by the approved budget of the court. To sum up, the really was a summary of the presentation is what Kaufman said is the lack of a direct causal link between Duterte ordering up and someone ending up dead. Kaufman repeatedly says that the Davao Death Squad is a media construct, and again he says there's no chain of order. There's no evidence that will say kung ano man yung sinabi ni Duterte at yun talaga ang nangyari sa dulo. If you see on your screen that ang tagal nung kanilang private session, before Judge Motok ended the session, trial lawyer Julian Nichols asked for a private session at nakita namin na may sinasabi si Nichols kay Judge Motok, si Judge Motok may sinasabi kay Kaufman. We will have no idea what is being said there, but that is how it ended, with a lot of details of who these witnesses are, and with Kaufman saying that the witnesses should be prosecuted on their own.
Yeah. Thank you, Lian. That's our Rappler Senior Investigative Reporter summarizing the last part of Kaufman's statement before the pre-trial chamber. So far, tapos na po ang 3 hours ng defense para po sa kanilang presentation on the merits. Tomorrow, they will have another 30 minutes. Last na po yun, the 30 minutes nila to finish and to wrap up their arguments and their submission on the merits or evidence before the court. To summarize lang din, overall, ito pong 3 hours na presentation ng defense ay umikot po sa pagda-downplay nitong witnesses, sa pag-atake po ng supposed witnesses nitong prosecution na nagte-testify against dito sa Davao Death Squad. ni former President Rodrigo Duterte. Dina-downplay din po in many instances. Kaufman also tried to downplay the killings by justifying na hindi naman daw seryoso si Duterte doon sa killings, na yung mga killings daw ay nag-fight back lang naman daw yung mga witnesses. And we can deduce itong statement at itong overall strategy ni Kaufman two-way. Una po, to establish na walang common plan, at number two, wala daw link itong pagpatayan kay Duterte on the common plan. Importante po kasi doon sa indirect co-perpetration ni Duterte na mapatunayan na may common plan or may planong sinusunod po itong mga perpetrators at indirect co-perpetrators, dapat may pinagkasundoan silang plano. At ang plano na po na pinag-uusapan daw dito ay yung patayan po nitong mga alleged suspects. So ang ginagawa po dito ni Kaufman, tinatry niyang patunayan at palabasin na wala daw talagang planong sinusunod at hindi daw organized, wala daw killings na inutos itong si Duterte directly. Pangalawa, wala daw link kay Duterte itong mga co-perpetrators o itong mga perpetrators o yung mga actual po na nag-pull ng gun. So yun po yung two-way approach na ginawa ni Kaufman. Pinag-usapan din po yung neutralization, isang napakalaking usapin din po in the 3-hour hearing itong neutralization, yung term po which human rights organization call as to kill. Yun po yung interpretation ng human rights organization. We're gonna look at the documentary evidence, the historical context of the term neutralization according to former Commissioner of Human Rights Karen Gomez-Dumpit. To kill daw ang ibig sabihin nun, but Kaufman is trying to downplay that meaning by saying na not even daw judicial records in the Philippines define what neutralization is. And tomorrow, yung 30 minutes po na yun, so far, itong si Kaufman ay hindi pa masyadong nag-zero in dun sa issue ng jurisdiction, which we expected na sana pag-uusapan ni Kaufman, because according to many experts, many observers, itong majority ng defense ni Kaufman would lie on the jurisdiction or kung meron po ba in the first place, sakop po ba ng kapangyarihan ng ICC itong si Duterte, at kung in the first place po ba ay dapat siyang inimbestigahan itong International Criminal Court. Tomorrow po, Friday, February 27, 2026, ay magaganap na po ang pang-apat sa 4 na araw na hearings dito sa Pre-Trial Chamber. Bukas po ay may 30 minutes pa ulit ang defense, kaya doon po natin inaasahan na mabibring up ni Kaufman itong issue ng jurisdiction. Pagkatapos po ng kanyang submission on the merits, magkakaroon po ng pagkakataon ulit ang prosecution, ang victims at si Kaufman ulit na magsalita for 30 minutes each. Sa 30 minutes po na yon, closing statement na po yon ni Kaufman, ng prosecution at ng mga victims. This is their last chance to convince the pre-trial chamber kung bakit dapat ma-confirm o hindi ma-confirm itong charges laban kay Duterte. Hindi pa po tayo, pagkatapos po ng 30 minutes each nila, magkakaroon po ng 1-hour hearing on the review of detention. Basically, itong korte ay titingnan ulit kung fit pa ba si Duterte na makulong po doon sa ICC. And under the rules po ng International Criminal Court, taon-taon pong i-review ng International Criminal Court yung detention ng isang tao. And in this case, reviewin po nila ulit itong kaso or pagkakakulong kay Pangulong Rodrigo Duterte. Continue to follow Rappler for our special coverage of these pre-trial hearings. You may visit the Justice and Crime Chat Room of the Rappler app for context-related pieces, which you can find helpful. We thank human rights lawyer and National Union of People's Lawyers President Efraim Cortez, San Sebastian College Recoletos Graduate School of Law Dean Rodel Taton, and UP Law Senior Lecturer and ICC Assistant to Counsel Ros Tugade, who joined us earlier. Thank you to Lian Buan and Michelle Abad, who reported from The Hague, Netherlands. This is Rappler's special call.